Thank you. Now, welcome. It is Monday, October 5th, 2020. Welcome to the virtual workshop meeting of the Commissioners of Rehoboth Beach. I'd like to call this workshop meeting to order at 9:33 a.m. I'd like to welcome members of the public to be watching us and participating in this meeting. Again, I wish we could see your faces, see how many are out there, and whether you're smiling or frowning. I'd like to conduct roll call vote as we normally do. Commissioner Ed Stranowski.
Present.
Commissioner Jay Legree.
Here.
Commissioner Susan Gay.
Here.
Commissioner Pat Caluzzi.
Here.
Commissioner Patrick Gossett.
Here.
Mayor Stan Mills. Who are we missing? We're missing Dick. I started prematurely, I guess.
Oh.
You drop off? All right, we'll continue and we'll note when Commissioner Byrne returns. Correspondence, the only correspondence I have identified, Ann, is a letter dated September 24th, 2020 from Caroline Park of the Rehoboth Beach City Beach Commerce. And that's a broad letter in support of implementing 5G wireless. So I'm not going to get into it anymore because Carol, I believe, is a speaker and can speak to it during the wireless topic. And we'll note that Commissioner Burns is back with us. Thank you very much.
Thank you.
Next is City Manager's report.
Thank you, Mayor. Good morning, Commissioners. Regarding the citywide street paving program, a pre-construction meeting was held last Tuesday, September 29th. Adel Construction is the contractor. They were also the contractor last year for the paving program, and they did a very good job for the city. The following locations are those that will be paved for the 2021 fiscal year. Sussex Street from Columbia Avenue to 5th Street, Lake Avenue from 2nd Street to Surf Avenue, and Stokely Street from Hickman Street to Scarborough Avenue. Wednesday, September 16th, city staff, as well as representatives from Hilton Displays and the Merge Design Group, completed a walkthrough of the wayfinding signage project. A punch list is being prepared for items that need to be addressed before the project can be closed out. Currently, the city has not been invoiced for any work associated with the project. They're still doing the closeout and the punch list. Last week, there was a very good turnout for the BB Flu Clinic that was held Thursday in the Convention Center parking lot. The next free flu clinic is scheduled for Thursday, November 5th, and also will be in the Convention Center parking lot from 1 to 5 p.m. The clinic is for those who are 18 years of age and older, and the specific event is a bike up and walk up event. Further information can be provided on the city's website. On Saturday, October 24, from 10 a.m. to 2 p.m., the Rehoboth Beach Police Department will join with the DEA to provide a safe and legal way to dispose of unused or expired prescription medications. Anyone can bring any expired prescription medications to the collection site in the lobby of the police department. It's free, it's open to the public, and more information is on the city's website. Regarding the Lake Avenue Streetscape Improvements Project Phase 2, construction began on September 14th. The contractor is currently working on curbs and sidewalks on the east side of 2nd Street. Once this is completed, they'll continue the same work on the curbs and sidewalks on the west side of the street. And the contractor will be working next Monday on Columbus Day from 7:30 a.m. to 5 p.m. Information, obviously, is on the city's website. That's all.
That all? Any questions, city manager?
Yeah, I have one
Commissioner Burke?
question, Mayor. Thank you, Sharon, for the report. And I just want to say that I really like the wayfinding signage. It's consistent, it's helpful. It seems to be in all the right places. My only question is part of the punch list taking down some of the old signs that are now redundant with the new signage?
Yeah, city staff is working on that, and will be continuing to work on that, yeah.
Great, thank you.
All right, thank you very much, Sharon. Ann Womack, I skipped over you.
As far as correspondence, I received a phone call from Dr. Trejos this morning. He had a piece of correspondence that was dated October 1st for the wireless communications facilities. I have embedded it into the agenda this morning, just prior to the meeting. It's a piece of correspondence that had been forwarded to all of you prior to this meeting.
Thank you very much.
Yeah, I saw that.
Up next, we'll go to City Solicitor's report.
Thank you, Mayor. Just a reminder for the commissioners that Wednesday morning we'll be having a executive session to discuss open litigation and some FOIA issues. Just as another update, it's not going to be don't expect it to be a decision-making meeting as far as any sort of strategy goes. I guess the agenda does allow for decision after the executive session if there's anything that comes up that we need to act on, but it's largely an informational session for the commissioners Wednesday morning.
Right, but it does allow for action if needed. Right. Thank you, Glenn. Any questions? If not, we'll move to our first line of old business is discuss program for wireless communications facilities and possible amendments to the appropriate zoning code based on recommendations by the Environment Committee. If you recall, the Environment Committee, I think back in August or so, came up with 15 recommendations, and those are the ones that we're taking a look at today. My expectation is that we will talk about each one of those recommendations from the Environment Committee individually, with comment by the city's consultant and city manager and city lawyer, and allow for discussion or input from the Environment Committee as well as those members of the public, also Verizon and AT&T representatives. So, Sharon, do you want to take it over? Thank you.
Thank you, Mayor. Yeah, just very briefly, you pretty much encapsulated what we're doing here with the agenda item. But for those who may not know, about 13 months ago, September 9th, 2019, the mayor and commissioners then adopted an ordinance providing for a regulation of tower-based wireless and non-tower wireless, and also small wireless communications facilities that are known as the Wireless Communications Facilities Ordinance. Since that time, last September, there's been discussion, there's been some public comment about some safety regulations, some health issues regarding specifically the 5G proposals that are being submitted now. And the Environmental Committee also discussed this at length. Based on, as the mayor said, in August, the Environmental Committee, their concerns, Mr. Mandelis and I reached out to Mr. Mike Roberts, the city's consultant from the Cohen Group that we had used basically to come up with the Wireless Facilities Communications Ordinance last year in 2019, and Mr. Roberts then formulated some responses to that. So with that, I'll turn it over to Mr. Mandelis.
Thank you. As the city manager said, we did work with Mike Roberts and got some responses, really inquiring about the Environment Committee's report and recommendations to see what were feasible, what were not, and what things maybe we should be thinking about in connection with each of those items. So, Max, is Mike on? Good morning, Mike, if you're there.
Hi, yeah, Glenn, I'm here.
Hi, Mike. What I'd like to do, so this is Mike Roberts from Cohen Law Group joining us. What I'd like to do is go through each of the Environment Committee's recommendations, and then, Mike, if you'd be willing to just give a brief response based upon your September 11 memo, just proceed that way, I think. Is that acceptable?
Yeah, absolutely, absolutely.
Mayor or Glenn, could I interrupt for just a moment, please?
Sure.
Yeah, thank you. Heather Metz, who is a member of the Environment Committee, is on the call with us this morning. And it seems to me that it would also be helpful for her to comment briefly on each of the recommendations. She's the primary author and has done the bulk of the research. And I think that would give us a balanced kind of approach to looking at each of these without making it too long or too laborious for us.
So my understanding in discussing with the mayor intends to allow for public comment, and from Heather and from the utility companies and from members of the public on each recommendation, so that we can get a full complement of thoughts on each of the recommendations as we go.
Thank you.
Thank you, Commissioner Byrne. However, we do have time constraints, so we want to be very cautious about our time. You know, want to give as much as possible, but I did advise the Environment Committee that we wanted to try to condense as much as we could some of their rationale. And if some of these recommendations were moot, that we were just going to go with them, that maybe they would forego a rationale possibly. Also, we've got on the line 3 representatives from Verizon. Rather than give each one 3 minutes, I'm hoping that they can do a total of 3 minutes or pick one person to speak on their behalf. We also have AT&T online also. So that's the way our program will go. We'll read a recommendation. We'll get Michael Roberts from Cohen Group's feedback on it, and then allow for commissioner discussion, and then we'll go to the Environment Committee via Heather Metz representing the Environment Committee, and then we'll go to the other members of the public. Commissioner Legree, you have a question?
Yes, thank you, Mayor. Before we start this discussion, I think we need to make it clear that the recommendations from the Environment Committee were made before the Ninth Circuit delivered their findings. So the answer to the recommendations from the Environment Committee have all had the benefit of knowing the findings from the Ninth Circuit, which changed everything. So I'd like to lay that groundwork before these discussions start. Thank you so much for letting me speak.
Thank you. And Commissioner Gossett?
Just to confirm, it's the August 7th document that we're going to review or should be reviewing?
September 11th.
Yes. Yes.
It's the August 3rd report of the Environment Committee.
Uh-oh.
There's the Environment Committee recommendations dated August 3rd, but then the feedback from Verizon is based on a version of recommendations from the Environment Committee dated August 7th. So I couldn't find much difference between the documents. Maybe the Environment Committee can articulate what the differences are. In the meantime, we'll go ahead and start. Each of the 15 recommendations, 5 recommendations are broad. The other 10, second set of 10 are relative to the permitting process.
So I thought maybe, like Commissioner Legree did with giving some background, I should have asked Mike Roberts if he had any upfront comments he wanted to make before we got into it. Mike, is there anything you wanted to say before we get started?
Absolutely, and thank you, Glenn, and thank you everyone for having me. I just wanted to, before we dive into the specifics of the Environment Committee recommendations, just give a bit of brief background on who our firm is, as well as a bit of brief background on the applicable law here. I'll try to keep it as brief as possible, but I think it would be beneficial as we go through each of the recommendations to kind of have some background as to where I am coming from in terms of the applicable law here, and I think as well as where some others may be coming from as well. Is that okay with everyone that's on?
Yeah, great. Thanks, Mike.
Okay, great. So just to give a quick background on our firm, we're a small law firm based in Pittsburgh, Pennsylvania, and we specialize exclusively in telecommunications matters, wireless, broadband, cable franchising, anything that falls under that telecommunications umbrella, our firm covers as a specialty practice. Our clientele is exclusively municipal. We have never in our history and never will represent the providers themselves. Our firm is specifically municipally oriented. We represent cities, states, towns, any sort of municipal client in their dealings with the telecommunications providers. And our goal always is compliance, first and foremost. We seek to assist our clients in bringing their regulations in the wireless realm into compliance with state and federal law as it exists at the time that we're working on those requirements. So that's just a bit of background as to who we are. When it comes to the applicable federal and state law, the city's ability comes primarily from the Telecommunications Act of 1996 when it comes to regulating wireless facilities here. The Telecommunications Act explicitly preserves local zoning authority over wireless facilities, but it does subject that authority to a number of limitations. And those limitations have kind of been expanded over the years via FCC order. But there are a few that I think are worth mentioning before we discuss the Environment Committee recommendations. The first is that local governments cannot prohibit or have the effect of prohibiting wireless facilities and the provision of wireless service. So prohibit is an easy one. The city can't simply say no facilities are permitted to be deployed at all. But effective prohibition is an important one to bear in mind as we look at these recommendations individually, because imposing regulations that are overly burdensome or that are really difficult to comply with can constitute an effective prohibition. So when we look at these recommendations, we're looking at them through that lens. What could constitute an effective prohibition? What could result in a potential legal challenge from providers that the city would then have to defend? Local governments also cannot impose moratorium on wireless facilities deployment. That comes from the Telecommunications Act as well as a subsequent FCC order known, of course, as the moratorium order, basically saying that we can't institute some temporary pause on the deployment of wireless facilities either. There's some leeway in cases of emergency there, but in terms of simply saying no applications are permitted for an extended period of time, that's also prohibited by federal law. And then finally, and I think this is the most important one to consider for a number of these, local governments are not permitted to regulate the placement, construction, or modification of wireless facilities based on the environmental effects of radio frequency emissions. That includes the perceived health effects on humans, the environment. Anything that deals with radio frequency emissions is solely within the purview of the FCC. And the FCC has promulgated around the time of the Telecommunications Act their radio frequency emission standards. Then they revisited those standards late last year and essentially upheld them in full. These regulations and the radio frequency emissions requirements have been challenged a number of times to no success to date. Courts across the country have kind of upheld that federal preemption when it comes to the regulation of radio frequency emissions. There's also one other order that I think is important to touch on, and that's the FCC's September 2018 third recording order that deals with what are known as small wireless facilities. Those are primarily the facilities that we're going to be be talking about being deployed in the public rights of way. And the FCC kind of did a wholesale revision of regulation of those facilities at the local level and imposed some really strict requirements on what we can and can't do for those facilities as well, including what would constitute an effective prohibition, which the FCC has stated is now considered a quote unquote material inhibition of the provision of wireless service, which includes things like densifying a network, deploying new technologies, addressing gaps in capacity, which differ from gaps in coverage, which are kind of what these new small wireless facilities are seeking to address, those gaps in capacity. And also regulations that relate to the fees and the costs that can be associated with deployments of small wireless facilities. So recurring fees are capped at $270 per site per year, and application fees are capped at either $500 for a set of up to 5 co-located antennas and $1,000 for new poles. So all of these requirements kind of create this regulatory structure that relates to what we're going to be talking about today. And I think it's important to think about these things up front before we dive into each of the recommendations, as these regulations are going to kind of govern and inform my responses to the proposed recommendations. Any questions about any of that?
No, I don't think so, Mike. Thanks for that background. I appreciate it. It gives us a good baseline to work from. So the first recommendation of the...
Glenn, let's just talk for a minute about what is our expectation coming out of this meeting. My expectation is that we'll review each recommendation from the Environment Committee. We'll get feedback from Michael Roberts and also Glenn and Sharon, and then from the Environment Committee, et cetera. Members of the public. And I'm not sure that we'll come to conclusion today on each of these recommendations, but if not, then we can bring it forward at the October regular meeting and even consider a vote on some of the items at that time, if that's all right with you all. So with that, Glenn, I'll turn it over to you.
Thanks, Mayor. So there's a group of recommendations that came out of the Environment Committee, first that deal with amending the zoning ordinance at section 270-46.1.2. So the first of those recommendations is that wireless communications facilities will be set back 60 feet from any residential dwelling unless approved through a conditional use proceeding. And Mike had some thoughts on that. Mike? Yeah,
so my thoughts on the conditional use recommendation are twofold. First deals with the question of timing. So federal law requires that the city address applications for small wireless facilities in either 60 days for a co-located antenna. That would be an antenna that's being attached to an existing pole in the public rights of way, and 90 days for a new pole. So these are very compressed timeframes, and it's important to note that that 60-day or 90-day timeframe includes or runs from the date of the application submission to the end of the process in its entirety. That includes assuming a conditional use process here, advertisement, hearing, decision process, as well as the issuance of any permits that are needed, and the execution of any agreements that are required on that 60th or 90th day. Everything that the city has to do to approve, assuming approval of a facility, has to be completed. So my first comment is simply dealing with timing. The city should consider whether it can accomplish a conditional use process in full, in a meaningful fashion, in that 60 or 90-day time frame. And given the setback that's proposed here, a 60-foot setback from any residential dwelling, from my understanding of the layout of the city, that's going to be most, if not all, wireless facilities deployed in public rights of way. A 60-foot setback, while also being in the public rights of way, is pretty far. So for essentially any small wireless facility being deployed in the public rights of way, at least in a residential area or where residential dwellings exist, it's likely that a conditional use hearing will be required. So my first comment is simply consider whether that process can be accomplished in the 60 or 90-day time frame from my experience with our municipal clients, most have not felt that that's a feasible time frame, particularly if opposition arises or if significant comment arises that can stretch that process out. At the end of that 60 or 90-day time frame, providers are entitled to seek injunctive relief in federal court and essentially obtain a court order forcing the city to approve their facility anyway. So that process can be difficult, and it can ultimately be kind of mooted by federal law at the end of that process. My second comment deals with what the rationale for this requirement would be. So if the conditional use process is considered or contemplated for the idea of allowing opposition based on radio frequency emissions, it's important to note that the city cannot, to the extent that a facility is in compliance with the FCC standards, deny any application based on radio frequency concerns. No matter how strong opposition may be, no matter what that concern might look like, if a proposed facility complies with the FCC requirements, federal law from the Telecommunications Act in particular prohibits the city from denying an application or otherwise regulating a facility based on concerns about those radio frequency emissions. So it's important to note that that process can invite comments of this sort, and then the city finds itself in a difficult position to where there's considerable opposition to hear, but there's nothing really that the city can do at that point to respond to that opposition. So those are my twofold comments on that recommendation.
May I speak?
Yeah, let's do commissioners first, right?
Commissioner LeGree?
I don't think any commissioner has any intention of violating the findings of the Ninth Circuit. And to violate the shot clock or to violate the medical emissions findings, I don't think any of us would be doing that. So to argue about a recommendation that was made before the findings were issued is a waste of time. I'm not going to vote for something that violates the FCC order or violates the findings of the Ninth Circuit Court. The only real contentions that Judge Schroeder had was she thought it was very troubling with in the discussion of aesthetics, and she thought it was a very difficult part of her decision. And we could be much better using our time to talk about some changes that we might want to make. And so I'll listen attentively, but I don't think the commissioners had any intention of making amendments that would violate the Ninth Circuit's findings.
Well, Commissioner, I think we're trying to be methodical here and need to address each one at a time, so it doesn't look like we're dismissing something wholesale without giving it consideration. Thank you very much. Any other commissioner comments?
Yeah, I have a couple of questions about it. First of all, I knew from previous information that Heather had gathered that there are a number, and from some that I'd found myself, that there are a number of other communities that have fairly significant setbacks. And in my mind, the health reasons, I mean, I know those are important, and I understand that those have been addressed, and that we cannot limit on the basis of that. But the issue of property values and aesthetics is a big one. And so I guess what I don't know is if the recent court opinion basically is going to change those communities that have already adopted these setbacks, or if, I can't remember what I read on that one, or if it was just related to the health reasons, or what we can do in terms of setbacks, because there does seem to be a precedent there in other communities, and it seems to be based mostly on the adverse effect on property values in residential neighborhoods.
And any other commissioner? Glenn, do you have?
I was just going to mention, maybe Mike wants to talk just briefly to the Portland case out of the Ninth Circuit and what his conclusions were, which largely related to aesthetics and not to radio frequency emissions. I'm not sure if you're ready to talk about that or not, Mike, but if you could give a little primer on what the result of that case was, it might help.
Yeah, I'm happy to do so. So the City of Portland case in the Ninth Circuit that's being referenced here was a challenge, kind of a group challenge from a number of municipalities and municipal organizations at the national level to the FCC's small cell order that I mentioned earlier. They essentially challenged that order in toto. Basically, each requirement of that order, and I can go through each of those individually if you'd like, was challenged at some level by municipal challengers. The Ninth Circuit Court ultimately upheld the FCC's order in full, save for two items. So what was upheld were the fee requirements that I mentioned, the $270 in recurring fees and the $500 and $1,000 application fees, the shot clock requirements, those 60 or 90-day timeframes for approval, the changes to the effective prohibition standard, and then the aesthetic requirements, which initially, and I didn't mention this really earlier, the initial aesthetic requirements, so anything that would relate to the design of a small wireless facility, were addressed by that small cell order, and the FCC had initially said that those requirements have to be objective, they have to be reasonable, they have to be no more burdensome than those applied to similar infrastructure providers in the public rights of way, and they have to be published in advance. So basically what that meant was the city would have to prepare, and we have prepared, comprehensive design requirements for small wireless facilities that are contained within some document and accessible to providers at the time of application, and that are essentially no more burdensome than, in the worst case scenario interpretation, any other occupant of the public rights of way, including wireline telephone providers, water providers, gas providers, anyone that's accessing the public rights of way, or other similar infrastructure providers, meaning utilities that are deploying similarly sized and designed infrastructure, which is kind of a difficult comparison, but can be other communications providers as well as electric providers typically who are deploying similarly sized boxes and transformer equipment. What the Ninth Circuit ultimately held is that about half of the requirements are in place. So they struck the requirement that the design standards be objective, essentially stating that any zoning requirement has a certain degree of subjectivity that is required. You all can appreciate, I'm sure, that when you're looking at a proposed project through a zoning lens and how that comports with the aesthetic characteristics of the neighborhood, you have to take each of those on an individualized basis because they're all in their own location. They're all kind of have their own design. So that was one prong that was struck by the Ninth Circuit. The other was the requirement that design standards be no more burdensome than those applied to other occupants of the public rights of way, for the reasons that I kind of alluded to a bit earlier, that small wireless facilities, while they may be comparable in size, are a distinct type of deployment from other occupants of public rights of way. And the federal law that the FCC was citing when they justified that requirement really didn't say what they purported it to say. It stated similar infrastructure providers, other similarly situated occupants, which would be other wireless providers. So essentially, that FCC order is upheld mostly in full, save for those two requirements. And then the Ninth Circuit also upheld a few other pieces of FCC regulation, including things like the moratorium order, stating that we can impose a moratorium on wireless facilities.
Thanks, Mike. Mayor, do you want to go to, if there's no other commissioner comments on this first recommendation, do you want to go to Ms. Metz?
Heather, let's remember time constraints. We'll have more time in future meetings. However, we want to preserve the time for Michael Roberts today as much as we can. Heather, are you there?
Yes, I'm here. Thank you, everyone.
Thank you.
I'd just like to start by saying that the proposal was very carefully crafted to make sure that we are meeting at the time the requirements of the FCC, and that there is nothing in the proposal that would give the city the authority to reject a wireless communications facilities based on health effects. That's not in here, and that was never really a consideration after the first discussion. So I just want to make that clear, that that is definitely not part of the proposal. As far as the first point, the 60-foot setback is merely in there to provide people in residential areas with a method to be informed, to have transparency about the process, about what's going on, so that they would be notified and there would be a process with the city that they could go through to make sure that, as the lawyer said, that the aesthetic requirements will be upheld. The FCC's decision that aesthetic requirements can be met as long as they're subjective is something that needs to be aired with our local government. And if those wireless communications facilities are just approved without any process of involving the public or our elected officials, then there's no way to guarantee that those aesthetics are subjective. That is the only way to do that. And I feel that with our city's meeting schedule of having workshops and meetings every 2 weeks, that it would not be a problem to meet that 60-day requirement.
Thank you, Heather. Remember, we're focusing on each individual recommendation. However, if you have something broad that might fit in, that would be welcome. Carol Everhart, please. Carol? If not, we'll... Carol, are you there? You might be on mute. We'll go on to, I'm sorry, Carol, we're not hearing you if you're there. Walter Brittingham, oh, are you there?
Can you hear me now?
Yes.
We can.
Okay, thank you so much. Technical difficulty, I guess. Well, you've seen our letter of support for the continuation of the 5G, and the letter is fairly clear of the main reasons why. You know, if you're going to, I'm going to put on my chamber hat, I'm going to put on my business hat and my visitor hat in particular, and the city hat. For the visitor, right now what we're seeing is a continuation and a growth in working from home, and they are choosing to move about when they do that. We are one of the move about locations. So definitely it is at this time, and as it's growing, something that is needed now and is going to continue to be a growth need in the future. And as far as the businesses go, it allows them to do business quickly in real time. So they are, of course, requesting that. And for those who may be moving here or may be opening business here or just visiting here, it is something they're looking for. So we just wanted to make sure that we made it clear that it makes business operations smarter to have this ability to move forward into the future.
Very good. Thank you very much, Carol. Walter Brittingham.
Good morning. Good morning. Thank you, Mike, for your explanations. I'm very concerned about aesthetics, and I think we need to come back about that, underground facilities, etc. And I think more than the underground, the poles themselves sitting out there, a 50-foot pole is something that you have to deal with, but we need to look at what's going up in Dewey Beach and out on Route 1 by the church up at Lewis, and people have no conception of what these things look like. And I think we need to have every way to take care of the aesthetics. I'm not concerned about the radio rules, but the briefing that you had at the last meeting by the expert, we're not going to do much against the federal government, but we have to reserve every right that we have to control what happens as far as underground transformers, etc. Even the utilities are having problems in the middle of this where underground is required in communities, and the Fed overrides this and allow poles and mandates that the utilities put up poles. So there needs to be a better working relationship, And there surely needs to be some work from SCAT and people like this to go back to the government to discuss what needs to be talked about. Thank you very much.
Thank you, Walter. We'll go to Verizon, Bonnie Metz.
Sorry, I'm going to let Megan Riley speak to this issue, please.
All righty, Megan Riley with Verizon. Thank you.
Hi, I'm sorry, I'm not clear on which issue I have been authorized to address at this point. Are we talking generally about Verizon's feedback or a particular, the undergrounding of equipment?
The setbacks. Huh?
I mean,
The setback issue?
I think, Megan, this is fine. We're really talking right now about the 60-foot setback suggestion by the Environment Committee and the conditional use process for those.
Thank you. Okay, yes, and I'm sorry, because Verizon did provide comment on a number of the items in the Environmental Committee's recommendations. So I wanted to confirm. Verizon does find the 60-foot setback requirement concerning because on its face, given the fact that our small cell deployments are in public right of way, that would not, I mean, we would not be able to comply with that, with the setback requirement that significant. You know, and we understand the concerns around aesthetics, and the law absolutely does give the city the ability to pass aesthetic criteria and guidelines aimed at, you know, making sure these deployments don't undermine the character of the surrounding community. And it's certainly within Verizon's interest, it's Verizon's interest to avoid the same. You know, it does not help us in the long term to alienate the communities where our customers live. So we are absolutely willing to work with the city on aesthetic guidelines, but the 60-foot setback on its face is going to render our deployment, it's going to effectively prohibit our deployments. If there's a notice concern, Verizon did note in our comments on the committee's proposal some feedback on how notice could be provided to the residents in the immediate vicinity of the deployment. So again, certainly willing to work with the city and weigh in on the best means for providing notice to residents, but don't believe that the 60-foot setback requirement is really tailored to achieve that particular objective.
Thank you, Megan. And just a reminder to everybody that there is a support document embedded in the agenda with feedback from Verizon that she's referencing. Next we'll go to Joseph Joseph of AT&T.
Hi, good morning. Thank you, Mayor, and thank you, Commissioners, for allowing us to participate. Generally, AT&T is in agreement with all of Verizon's comments with respect to this document. I would say for this, the 60-foot setback seems very arbitrary, does not at all distinguish between existing structures or new poles, when in fact, I think you want to have providers use existing poles if at all possible. So this is very arbitrary, yet the placement of small cells for whatever purpose is not arbitrary. It is based on engineering data and analysis on where this infrastructure is needed. So there really is a question of how did 60 feet become the determinant, or how is it selected? It seems like it's a veiled attempt at the radio frequency. But so it would be a problem given the right of way and the way it is in Rehoboth. Thank you.
Thank you, Joseph. Unless the commissioners have any further comment on number one, then we'll go to number two. Commissioner Calusi.
Yes, thank you, Mayor. From a practical viewpoint, that was also my thoughts. The idea of the 60-foot, if we're just talking about the idea of the aesthetics, it appears to me that if you start putting in additional requirements for 60 feet or whatever number of feet you choose, you might end up with putting up more poles. And that was my concern. I didn't quite understand what the 60 feet was about, because based on the diagram I've seen, I think that both Verizon and AT&T are trying to use existing poles, and it's something that we talked about early on, when we started talking about this probably close to a year ago. To me, that makes a lot of sense. So I'm not sure what the 60 feet buy us. So if someone can address that, that would be helpful. Thank you.
Any other comment by the commissioners? If not, that concludes discussion of recommendation number 1 of 15. We'll go to number 2.
Mayor, could I make just one comment?
Yes.
We've talked a lot about the aesthetics, and I thought that we passed a design standard, some type of design standard or aesthetic standards related to this back in the fall of last year, where it would come before the commissioners specifically as a conditional use rather than, I believe, the Board of Adjustment. If there was a dispute in the design standards. Glenn, could you?
Do you recall? I don't recall anything passed.
So we did pass, you all did pass a series of design guidelines. A standard wireless communications facility, one of the small wireless communications facilities, generally will not come before the commissioners. Now, Thursday, my recollection of the ordinance, and Mike may be able to speak to this as well, since he was the primary drafter, that I believe that a new tower would come before the commissioners. But there may be some variance process that goes to the Board of Adjustment. I just don't recall. Mike, do you?
So per my recollection, and forgive me, I don't have the design standards pulled up right now. For new towers and new non-tower facilities that are not small facilities, those would be conditional uses. For disputes as to the design standards, I believe that would go to, at least in the last draft I recall, the city manager, I believe, for dispute, for resolution of that dispute. So I believe that was simply a time frame question as well, that once a dispute arises and we have shot clock time frames to contend with, we want to be able to resolve that dispute as efficiently as possible.
I just thought it was, and I'm having trouble finding it from the fall of last year, but I know that it's something that we passed, and I thought it was relevant in this topic, since we are talking about both conditional use and the aesthetic aspects of it.
Yeah, I appreciate that. Perhaps the Environment Committee could comment, but I think most of their recommendations were not really with an eye toward aesthetic. It was more radio frequency emissions and those sorts of issues, I believe. Do you want me to go to number 2, Mayor?
Yes, please.
So the second recommendation is add a provision to make clear the wireless provider is required to demonstrate that the installed wireless communications facility complies with any new or amended requirements issued by the FCC or authority having jurisdiction. The city will annually review the permit for compliance with FCC regulations and have the right to revoke the permit and demand removal of the wireless communication facility if any new or amended requirements are not being met. Mike, comments?
Yeah, some of my comments here are going to speak to item 3 as well, so forgive me if I reiterate them when we talk about the next point as well. As a preliminary point, I'd like to note that the ordinance does require proof of compliance with the FCC standards that are in place. It's in sections, and there's the same requirement reiterated for each type of wireless facility. So section 270 46.1.2 A1J. I realize I'm giving you long citations here. 270-46.1.2 B1G and 270-46.1.2 C1G For each application, for each type of facility, compliance with those FCC standards are required. The application would then require proof of that compliance. Typically, that's provided via a radio frequency report that's prepared by a certified radio frequency engineer at the time of the application. So that's item one. When it comes to annually reviewing the permit for compliance, my comments are more at a practical level than anything. I do have a few concerns both with this and then the next comment when it comes to compliance with those recurring fee requirements. But in terms of practical comments on reviewing the permit, my question is simply, what would that procedure look like for the city? I think that's something that we have to consider. Who performs that annual review for compliance? Who at the city staff level, assuming it's through city staff, will be kind of making these calls as to compliance with those radio frequency emissions requirements. And then both for items 2 and 3, when it comes to cost, assuming we are determining whether either the city or the provider is responsible for any costs associated with this. The fee schedule that we initially discussed when we passed the ordinance a while back pushed us up to that maximum FCC fee level of $270 per site per year in recurring fees. To the extent that we're imposing additional requirements beyond that are going to impose additional fees on those providers, the city does open itself up to some challenge when it comes to exceeding those FCC fee levels. To the extent that we exceed those fee levels, we have to show that those costs are reasonable and that the fees being charged are a reasonable approximation of the city's actual costs as it relates to the management of these facilities. So that question of quote unquote reasonable fees arises to me for both of these items as we're requiring additional items beyond that initial proof of compliance with the FCC levels. We have to really justify those additional fees that would be associated with any sort of additional burden when it comes to recurring proof of compliance, independent proof of compliance outside of the provider's staff engineer that typically prepares those radio frequency emissions reports. So typically what we see is language similar to what's in the ordinance now, requiring initial proof of compliance with the FCC requirements. And then to the extent that there is any sort of recurring proof of compliance required or recurring certification required, that's typically done at a bit of a longer time frame, whether that be 3 or 5 years, something along those lines. Or, and this is kind of most frequently the language that's used, anytime a modification occurs to the facility where the RF emissions might be affected in some fashion, whether that's upgrading the antenna, replacing the antenna, making some sort of change to the equipment itself. Otherwise, the facilities tend to kind of operate at the same level throughout the duration of their life.
Glenn, Mike referenced recommendation number 3. Could you read that and let's combine them together so that comments pertain to both of those at the same time?
Yeah, thanks, Mayor. I was going to suggest the same thing because they're closely related. They both deal with ensuring compliance. So number 3 says, add a provision that the wireless provider is required to have an independent licensed radio frequency engineer measure emissions from each small cell at the site, certify that the wireless communication facility itself and in combination surrounding RF emissions complies with FCC regulations at the time of installation, and submit a yearly report to the city. Each application shall include 3D modeling of radio frequency emissions for each proposed site. Mike, I know you commented on this in some ways. Did you want to add anything?
I think generally I covered most of what I wanted to say about this one. The 3D modeling requirement, I think, is fine to the extent that we want to expand or clarify what exactly we're expecting when it comes to a submission here. But again, questions of independent when providers are typically using staff engineers, all of this is going to have questions of cost. And I'm sure, to the extent that we open to the providers, we'll hear the same comments from them as well. So my concerns as kind of special counsel here deal with exposing ourselves to legal challenge when it comes to reasonableness, exceeding FCC fee ceilings as they're called. But I think, requiring proof of compliance, requiring some sort of recurring certification or statement of ongoing compliance, and requiring that notice be provided when a modification is made that may affect the RF levels are okay if the city chooses to pursue that route.
Very good. Anything from Glenn?
No, thanks, Mayor.
Commissioner, open it up to commissioners before we go to the public. Seeing no comments. Seeing no comments, we'll go to the members of the public. Carol, do you have more that you'd like to say, or?
I think I'll leave procedure and cost up to the city.
Thank you very much. Heather Metz, please.
Yes, Mayor, thank you. The goal of these two items was obviously to ensure that the providers are complying with the FCC regulations. There's obviously no way to know if you're complying with the regulations unless you actually do the testing. So that was the goal of these two items. This language is based off of what other cities have used and requirements that other cities have to use an independent certified radio frequency engineer to ensure compliance. As we move forward with the densification of these networks, there's going to be an amount of overlapping radio frequency. So it's just another way to ensure that everybody is in compliance. There may be in the future more players than just Verizon and AT&T as all of these systems are built out. So again, here, you can't have compliance without testing, and that was the goal. Thank you.
Thank you, Heather. Bonnie Metz?
Sure. Yes, hi. So I had asked Andrew Peterson, who's a licensed professional engineer who specializes in RF design and compliance, to join us today just to talk to some of these issues and also to answer any questions that the commissioners or you may or may have about RF and safety and things. So I'm going to turn it over to him briefly, and he's going to respond here.
Good morning. Good morning, commissioners. Good morning, Mayor. So on this point, I'd like to just clarify here that wireless providers are required to demonstrate compliance with very specific exposure criteria. That exposure criteria is set forth in the FCC's Office of Engineering Technology, Bulletin 65. And as per Bulletin 65, a predictive study of anticipated exposure levels is an adequate demonstration of compliance. In fact, it's quite necessary because oftentimes, as in the case here, with the application, it is required that a document, a report, be provided that demonstrates compliance. And of course, we can't go out and measure something if we're only at the application stage. Also what the OET 65 document focuses on is on the details, and it prescribes the formulas and details the exact methods that folks myself are required to use when evaluating proposed facilities like this. Not only do we evaluate a facility like this at ground level for folks that are in the vicinity walking past, but we also are very careful, particularly with small cells, to evaluate all locations of public access that could be elevated. So nearby balconies, nearby rooftops, where folks can find themselves working or recreating at an elevated position where exposure levels potentially could be greater. So what we do, and I do these routinely for Verizon and other wireless providers, is we evaluate these facilities on an individual basis at ground level and at all elevated positions surrounding to demonstrate compliance. And oftentimes, the case that we find is that they're compliant by margins of 100-fold in many cases, particularly at ground level. Thanks.
Thank you, Andrew. We'll go to Joseph Davis, AT&T.
Yes, sir. Thank you. I would just agree absolutely with what Andrew commented. You know, we under our license are obligated to operate within FCC standards. And to do anything otherwise would jeopardize our license, which is very significant. And there is no, I think as Mike Roberts talked about, if there's a modification to the site, yeah, then there is some merit to making sure that that modification still stays within the parameters of the FCC guidelines. But to simply create this regime because we might not be following the obligation of our license seems a little it just questions what the motives are, because we are obligated to meet the FCC standards as part of our license, not just in Rehoboth, but everywhere. Thank you.
Thank you, Joseph. Any more comment from the commissioners or Glenn? Commissioner LeGree?
I would like to ask if the two previous commenters, the professional engineer Andrew and the gentleman who just, are you employees of Verizon and AT&T?
I am an employee of AT&T. This is Joe Divis. Yes, sir.
Okay. Andrew?
No, it's Andrew Peterson. No, I'm not a direct employee of Verizon Wireless or AT&T. I'm an independent licensed professional engineer with specialty in compliance matters with regard to telecommunications facilities.
Are you under contract to AT&T or Verizon?
I am contracted on a project by project basis. In this case, I am contracted at the moment with Verizon Wireless for this project.
Thanks, guys.
Thank you.
So Mayor, numbers 4 and 5 are similar. They both relate to informing the public, so maybe we'll take those together as well. I'll read both of them. So 4 is add a provision to notify all residents within 500 feet of the location where a permit application has been submitted to the city. Each applicant should be required to post signage at the proposed site within 5 days of submitting the application for WCF with application number and contracts for additional information. Number 5 is all applications should immediately be posted to the city's website. Property owners shall be provided with opportunity to present written comments on any application, and such input will be evaluated by the city as part of the application review process. So Mike, thoughts on the notification provisions?
Yeah, so both 4 and 5, as my responses note, are fine in my eyes in terms of compliance with applicable law here. 4, in the very least, is required by a number of municipalities. I've seen that quite a bit in terms of notifying a certain radius or certain adjacent properties, however that location is defined. And 5, providing public comment, I think is absolutely fine in terms of compliance. In terms of what we can expect from that comment, I think it again bears repeating that when the floor is open like this, it invites comments about things that the city cannot, under federal law, control or respond to in a way that may be expected. So I think that's important to keep in mind here, just simply in terms of knowing what to expect. The city likely will get comments on radio frequency emissions, encouraging denial, encouraging prohibition of the facilities, encouraging moratoria in toto, and we simply cannot do that. The requirements in general, I think we're fine to put into place should the city wish to do so, and may offer opportunities to hear comments on aesthetics, on service requirements, on a number of things that may be beneficial to the city. But I think, again, it bears keeping in mind that to the extent that this is geared toward radio frequency emissions, or we expect radio frequency emissions related comments, the city can be in a difficult place when it comes to responding to those.
I'd like to comment, and that is on, it gives me pause a little bit to notice, give notice to people, because I think when you do that, you give them notice that there's going to be a tower built next to them. I believe you give them the expectation that there's a possibility of complaining about it or getting it stopped. And what I'm hearing is there's not that opportunity. So I think if we go forward with this noticing program, we've got to be very careful and manage what the expectations are. And that is that there is likely nothing that we can do to stop these antennas going up where the permit is submitted for. Any other commissioners?
Yeah, I do. I take your point about that it invites comments, criticisms that we may not be able to act on. But in general, I feel like it's better to notify people than to keep them in the dark, just in general about everything. And so something like this, it could be right in their public right away. I think they have a right to know. Let's put it that way. However, I will also say that this perhaps could take a lot of staff time. I don't know. I'd have to hear from the city manager on that. And I am a little concerned about the amount of time and expense that might be involved. Do I understand correctly? Are we already charging the maximum that we can for application fees?
I think that's correct. Yes.
Okay, so we don't really have the opportunity here to increase the fees to cover whatever cost would be associated with the notification. But I mean, in general, I think notification is always a good thing.
Great. Commissioner LeGree.
Yeah, I will agree with Commissioner Gay. Yes, it's true that hearing anger from things we can't control is frustrating, but I believe before I go too much further, I want to ask the representatives from AT&T and Verizon just how long it's going to be before they bring antennas into our neighborhoods. As I understand it, you're not transmitting 5G signals right now, are you? AT&T. Joe, let me ask. Is it Joe? Let me ask that question.
AT&T is. It's a good question, Commissioner. AT&T is providing 5G service through its macro system and certain elements of radio frequency spectrum. Our small cells in Rehoboth are not part of the 5G provisioning of service.
And how long will it be before you go into our neighborhoods with antennas and service?
Right now, we don't have any additional plans for constructing any additional infrastructure at this time. What that means, how things change, how the dynamics of customer usage changes over time, I can't predict, nor would I think it would be appropriate. And I wouldn't want to tell you something that wasn't factually correct.
Thanks for being candid. Could I ask the same question of the Verizon representative?
Sure. Hi, it's Bonnie Metz for Verizon. We do have 28 applications that are in. The majority of those 28 or the permits are in the commercial areas presently. I believe, and they will be 5G. They are not operational at this point, obviously, but they will be 5G. We may have a handful more of applications to come in. I'm not sure of the timing on that, but I believe, like I said, that we have maybe a handful more that we're contemplating, but the exact locations haven't been determined yet.
Well, as the newly elected chairman of the Boardwalk and Beach Committee, I have some real questions, but we can put that off for another time. My question, how long it will be before you start broadcasting from those antennas to the folks on the beach in 5G? Can you say anything at all about that, Bonnie?
I mean, we're trying to get them up as soon as we can, and particularly interested in getting what we have planned there built before the summer season comes around again. With the nodes on the boardwalk, we need to get approval, then we need to fabricate the poles. I mean, so we need to get fiber, so it's probably going to be months is what I guess, but I can get you a better, talk to the RF engineer and get you a better response, sir.
Well, thank you. I'm probably fine with your answer. do you anticipate people being able to buy 5G phones next summer, other than from Samsung? Or what are your thoughts along those?
Yes, there are 5G phones available now, and I think that the market's going to keep growing and growing. By next summer, I bet there'll be a lot of them, frankly.
Well, I'm sure the market will grow. Thank you very much for your answer.
Still on
Thank
the
you.
table are the recommendations and responses that you have to recommendations number 4 and 5 from the Environment Committee. Commissioner Calusi?
Yes, thank you, Mayor. My remarks are in regard to yours and Commissioner Gay. I also am concerned once we start. I agree, we need transparency, we need to let people know, but it is going to be frustrating when basically people come and say, you know, we're against this because of, for example, the radio frequency, which we can do nothing about. I am concerned about the cost of real cost with the city manager and her staff, and cost in time for other officials, elected officials in the city. So I am concerned about this. Has got to be couched very well in terms of what these people who may decide they're not happy with what cell site goes up, you know, what they can do or we have to manage their expectations. I guess that's really going to be so important moving forward. Thank you.
Thank you. Commissioner Sharnowski and then Commissioner Gossett.
Yeah, thank you, Mayor. I do agree with what you said, Mayor. People will have an expectation that they can say no or get it changed or moved, but we need to manage those expectations with clear communication in the notices, that there's not a whole lot of wiggle room. We can reference the design manual as something that we can, is really the only way to have something changed. And we just have to manage the expectations with clear communication on what we can control and what we cannot control with these facilities going up. So I do think it's very important. People have a right to know if one's going up next to their house. 500 feet might be a little larger of a notice area than we need, but I think certainly someone needs to be notified if it's going up directly next to their home. Thank you.
Thank you. Commissioner Gossett?
I also believe that setting expectations of what really could be done once notified to outline specific what relief is available for a homeowner if they are confronted with a installation going up within 500 feet of them. And also then some further investigation of how that really affects the shot clock, the timing. There may be a very short period of time that it could be reacted to stay within that 60 or 90 days. And staff time to put that together and to manage that process. So just all considerations of going forward. Again, the issue is what relief can be provided to the property owner, and in very specific as to what can or cannot be done in areas of a site being installed next to them.
Thank you. Commissioner Byrne?
Thank you. As the committee discussed this, they also discussed, and Heather can elaborate on this in a moment when it's her turn, but the committee also discussed, well, maybe 500 feet is perhaps too much, and maybe the notification goes to those that are immediately adjacent to the antenna. So that could be an option. Another option, if we deem that it's too expensive in terms of both time and cost to the city staff, is simply putting it out on the city website and, you know, working at getting people to increasingly look for notification on the city website. And then, of course, how it is stated, like we've just heard from the last couple of commissioners, I think is incredibly important.
Thank you. Commissioner LeGray, do you have something relative to recommendations number 4 and 5?
Yeah, I want to echo Commissioner Kaluza's remarks. She's saying the exact same thing that Judge Bress said in the Ninth Circuit when he gave the minority report. Thank you so much.
Thank you. Any other commissioners? Glenn? We'll go to members of the public then. Carol Everhart, do you have something on this topic?
No comment, thank you.
Thank you. Heather Metz?
Yes, thank you. I just want to reiterate again that there's really nothing in the proposal that is intended to prohibit any installations in commercial areas. I completely agree with Carol Everhart that this will be a benefit to the community. This is really about making sure that the wireless providers meet the expectations of the FCC and to provide a means to protect the aesthetics and the property values of our residents. You have to also keep in mind that every time the city issues a permit for a wireless communications facility, that gives all of the wireless communications companies the opportunity to co-locate in that same area. So that's also something to keep in mind. At the rate that we're going, the proliferation in Rehoboth, based on the ordinance we have now, we have a potential of 35 wireless communications facilities in a 1 square mile city. That's 1 for every 43 permanent residents of the city. And I would just like to comment that that is probably unprecedented in my research in the entire country. And I think that the wireless companies are taking advantage of our ordinance. And that, again, part of this is to let the community know what's going on, to give them the opportunity to enact the aesthetic, the abilities we have to control things based on aesthetics, and also to point out that there was a study done that property value reductions can be as much as 15% of a wireless communications facility going in front of someone's property. So I think there is an obligation on the city's behalf to be transparent, to let community members know what's going on. And I agree, Commissioner Burns, I think posting on the city's website is also a great idea. Thank you.
Thank you, Heather. Walter Brittingham?
He's behind 30 seconds.
Walter, you still there?
He's getting the delay.
Good morning again. I think you should all be very proud of the discussion you're having, both from the technical people and the questions coming from the commissioners. Keep up the good work.
Thank you, Walter. Any Verizon representatives like to speak?
Sure, this is Bonnie. I just have to say we don't have any objection with 4 and 5, the notice requirements. We do, however, believe that 500 feet is excessive, as some of the discussion was stated here, that you would be impacting people that couldn't even maybe see it. And depending on how close you put them, you're going to have a lot of comments. But again, we don't have any problem or objection to providing notice. We believe it, should be limited to adjacent property owners probably, but we'll wait to see what you all decide. Thanks.
Thank you, Bonnie. Joseph, AT&T?
Yes, sir. Thank you, Mayor. I would concur with Bonnie and some of the other comments the commissioners made about this arbitrary 500 feet just seems incredibly excessive and throwing a dart up against the wall. The other thing I think the ordinance that is in place now, as many of the commissioners who were sitting at that time remember, this was a significant very public process that was instituted by the city and the board and the staff. So comments regarding the ordinance that's in place, I think are a little misguided, because I recall being in a lot of meetings where there was a lot of thoughtful questions and a lot of deliberation to find something that was in the city's best interests, the citizens' best interest, and also was balanced in allowing for us to serve our customers who are your constituents. So I just recall that, there was a lot of work that went into where we're at now.
Very good. Thank you very much. Any further commissioner comments? Or Glenn, you're okay? We're okay. we'll move on to the next 10. I don't know if there's a way to bundle any of these together to expedite a little bit, but the next 10 recommendations all deal with the permit application requirements.
The first of these 10, Mayor, really relates back to number 3, dealing with certification. So Mike may have additional comments, but I think they're pretty much summed up in his comments to number 3. But this one says, report by wireless communications company conducted by an independent certified radio frequency engineer showing radio frequency emissions measured in the area prior to installation. Report must show that calculation of RF totals after installation of new antenna meet FCC Bulletin 65.
Any commitment?
So Mike, is it pretty much the same comments to number 3?
Yeah, that's correct. And might I suggest, if we're looking kind of to bundle suggestions, maybe bundle this one with 3 here, which kind of relates to the same thing. Total RF levels for co-located antennas there as well. My only comment here is for 1 and 3 both, again, to reiterate the requirement that's in the ordinance now requires proof of compliance that the proposed facility, along with all existing facilities at a specific site, are in compliance with the FCC levels. Beyond that, I think we've covered this adequately for these 2 comments.
So I read number 1 in this bundle. So number 3 in this bundle is a new WCF co-located with an existing WCF on a single structure could potentially cause human exposure to levels of radio frequency in excess of the limits of FCC 1.1310. Provide a report showing total radio frequency levels co-located antenna. So what Mike's saying is that those 2 are very similar. And again, it's a requirement of demonstrating compliance. And his comment, the ordinance does in some way already require that.
Any commissioner comments on 1 and 3? Trying to expedite here, but let's go to the public again. For 1 and 3, Heather, Carol.
Just in general, it's the same challenges we continue to have, which is how to move forward and modernize our amenities and somehow keep our small town charm that we have. But beyond that, no specific comment.
Thank you. Heather?
Can you guys hear me?
Yeah.
Sorry. I think one thing that's important to note is Verizon or AT&T submitting a letter to the city saying we are in compliance is not exactly the same thing as them having an independent radio frequency engineer go out to the site and actually take pre and post installation readings. What we would perceive in the future is that as more antennas are rolled out and as there's higher density in our community, that we're going to need to be more on top of monitoring these radio frequency emissions. And the goal here is to get an actual field test by an actual person, not just a certification letter. And also, I want to speak to the idea that, again, this is for the future, and that I don't think the providers are required in any way to provide an overall plan for their build out in the community. And that's something that we take seriously. We work on our CDP, we make sure that we have direction going forward. And I don't really feel like there is that requirement, or there is a plan really for a complete build out in our community. It feels like these are just being added on piecemeal. AT&T has a bunch now, a bunch later. I think that's just something to keep in mind. And again, the goal is to protect our residents, protect our aesthetics, protect our property values, and to ensure the community that when the city of Rehoboth says that we have a wireless network that is efficient and safe and well-planned, that we can give that guarantee to our community by saying, here are our test results. We do our testing and we take it seriously, and we've done everything that's required.
Thank you, Heather. I'm going to get back to the public in 1 second. Ann Womack has her hand up.
Mayor, I've just received an email from a Michael Fisher. He's the treasurer of the Henlopen Condominium Council. And his email states, I'm watching the 5G meeting now. Not clear if you're discussing low, mid, or high band 5G. And what's the distance between the proposed antennas?
There is a map. Okay.
I can
Are we prepared to
say
respond
that
to him, or we need to get his email and response separate?
I'm not prepared to respond. I don't know if Mike wants to comment on the difference between low, medium, and high frequency and whether that's relevant to this discussion or not.
Yeah, I can give a quick response. What we're discussing here really isn't defined by a generation or a frequency one way or another. The way the FCC defines small wireless facilities and the way the ordinance defines small wireless facilities is strictly a dimensional definition. So what we're discussing are facilities that are 50 feet or less in height, antennas that are 3 cubic feet or less in volume, and accessory equipment, so anything that's not the antenna that's 28 cubic feet or less in volume. So really it's anything in the public rights of way. So it's not a question of, and I think this bears or is important to discuss in terms of the discussion of 5G as well. We're not targeting 4G, 5G, any sort of generational facility or service deployment. It is strictly pursuant to federal law dimensional definition that we're discussing. This will cover 5G, it will cover 4G, it will cover simply any facility deployed that meets that dimensional requirement.
Thank you, Mike. We got, again, we'll get back to the public, but we have some commissioners with their hands up. Commissioner Calusi and then Commissioner Gossett.
Yes, thank you, Mayor. I think I'm directing this question to Michael. The number one, the report by Wireless Communications Company conducted by a certified radio frequency engineer showing emissions prior to installation and after installation. I guess my question to you is, are we these types of demands, are we going beyond what is typical for most municipalities? It seems to me that one of the, I believe it was the AT&T engineer maybe, said that, their license depends on them meeting FCC rules. And I presume losing your license would be a rather major deal. Could you address those two things for me, please?
Yeah, absolutely. So what is typically submitted with an application in terms of certifying radio frequency compliance is not typically just, a one-page letter or anything like that. An application will include a radio frequency emissions report prepared by an engineer, and I'm sure the engineer that's on the call can speak to that as well. But it's a comprehensive document with data that is showing that the proposed facility is intended to comply with those radio frequency emissions. As mentioned, requiring something like that at the time of submission of the application, the facility hasn't been built yet. So it's a prospective requirement. The FCC's standards permit that as a submission that will satisfy their requirements. That's the most frequent type of submission that's required by municipalities. Some municipalities do go further. That imposes an additional burden on the providers in terms of field testing and things like that. But in terms of what is typical and what is submitted at the time of the application, that is what the city can expect from a provider. Will be a report prepared by an engineer detailing the proposed output of the facility, the type of equipment being deployed, and how that output will be in compliance, what percentage of the standards or the maximum standard will be emitted by a proposed site.
And then a related question is this idea of the co-location or AT&T perhaps having their cell and then Verizon adding on their antenna. Is there some provision for that one of them has to make sure that the total radiation isn't going to exceed FCC limits, or is that something that should be listed?
Yes, so the small wireless communications facilities, if assuming that's what we're talking about specifically, I can point to the actual citation there, 270-46.1.2 C1G. That encompasses the radio frequency emissions requirement for small wireless facilities in particular. And it does say the proposed facility along with all other facilities at the site. So the total emissions at the site will have to comply with the FCC standards. That language is echoed for every facility, including tower-based facilities outside of the rights-of-way, which will be your large macro towers, or non-tower facilities, which will be antennas that are attached to a building or a water tower or some existing structure. So any deployment will have to consider the total output at a specific site, not simply saying, hey, this antenna is in compliance, never mind that there's 15 other antennas at this site. They have to look at the site and tell them.
Thank you for that reply. It's very helpful.
Thank you. Commissioner Gossett?
Yes, just to follow along on Heather Metz's comments about planning for a complete build out in the city. And Mr. Roberts, perhaps you can address this directly. Is there an ability for the municipality to limit the number of total sites within a city, or limit the number of sites that a single provider has within a municipality?
So there really is not. To the extent that a proposed facility will not comply with something that we have in place now, there is some limited ability to deny a facility. But if a provider is showing a need for a facility in some fashion, whether that be a gap in capacity, densification, whatever that case may be, pursuant to the FCC order, denying that facility would constitute effective prohibition of that. So our ability to have AT&T or Verizon come to the city with a plan in place, showing a need for a facility, and the city to kind of step into the shoes of a provider and deny that facility, we expose ourselves to a challenge at that point in terms of that being an effective prohibition or a material inhibition of the provision of service. So when it comes to consideration, we really need to look at bona fide zoning concerns that we have in terms of the ability to deny a specific application rather than saying, hey, you've hit this 20 facility mark, you're done. Because at that point, we are effectively instituting a moratorium, which is expressly prohibited by federal law from the very beginning of wireless facilities regulation and then reiterated as time has passed on. So anything, I think, as a general rule, anything that is prospective or looking at a kind of wide-ranging, any facilities from here on out, any Verizon facilities are prohibited. We really can't do under federal law as it stands today. An important thing to note also, and I don't know that this specifically touches on your comment, Commissioner, but I think it's important to note, is that we also can't discriminate amongst providers. So we have to treat everyone exactly the same. So if Verizon is selling facilities and AT&T wants to do the same, we have to treat them equally and give all the providers a level playing field. Anyone deploying a wireless facility, a level playing field under the ordinance as it stands.
And is there any ability to maintain, if you will, current technology in the sense that we have 4G and 5G, and that with the proliferation of antennas in the city, that the provider has to have the most current technology available in the sense so they've not got a 4G and a 5G hung off a pole and 4G is going to go away along the maintenance or the current technology that's available?
To an extent, yeah. And let me know if I'm not directly addressing what you'd like me to here. But what we do is we require that to the extent that a facility has been replaced or a facility is no longer in meaningful operation, that facility has to be removed. So we're not in danger of Verizon hanging a 5G antenna and leaving the 4G antenna on. Once they upgrade or modify and they no longer use that existing antenna, it has to come down within a specific time frame. I believe it's 90 days under the ordinance as written right now. To the extent that we would want to tell the providers what technology they have to deploy, unfortunately, no. We are not granted the ability to do that under federal law. That's considered a business decision, and we're not able to kind of regulate the business decisions of any of the provider when it comes to specific technology, specific brand model of antenna being deployed. To the extent that it's not an aesthetic concern, we're not really able to do that now.
Thank you.
Thank you, Commissioner Gossett. Remember, we're focused on recommendations 1 and 3. We got interrupted for the public session. We'll go to Verizon and then AT&T. Does Verizon have any comments on 1 and 3? Andrew?
Yeah, hi. We do have some comment. So with when it comes to co-location on small cell structures, it's extremely rare. Now we're not talking about the macro towers or rooftops of things of that nature, but with these small cell structures, it is extremely rare. I've looked at thousands of these at this point, and I can count on one hand the instances of co-location. That's for a number of reasons, mostly though because of height requirements and separation requirements that the providers have. They can't share antennas. So there needs to be some separation in those antennas, and these being relatively short structures that limits height availability. So if that instance were to occur, though, I have no doubt that a demonstration of compliance that complies with the guidelines in OET 65 can be made available. The more likely scenario is that there be perhaps small cells in proximity to one another. And that will generally only make a significant impact on the overall exposure environment in cases where that proximity is within about the height of the tower. So if I can just very quickly attempt to share a slide and let me know.
We can see it.
Okay, good. Now this is typical exposure from a 5G small cell. Back to the question earlier, this is specific to a high band only small cell deployment. And you can see that beyond 25 feet or so, we're at very low levels, 0.05% of exposure levels for the general public, even at the maximum, around the height of the proposal here, where we're about 25 feet. Beyond that, the levels fall off very quickly. At 50 feet, we're half, and then so on and so forth as we move away from the facility at ground level. Drop dramatically. So really, when we have small cells within the shadow of one another, perhaps there could be a significant contribution. I still would never anticipate exposure levels beyond the FCC limit. However, when we have that, we do, as a matter of course, take those into consideration and include those in any calculations. And that would be the case here with any potential for co-locate or for multiple small cells within proximity of one another. The other point that I wanted to just touch on briefly was anticipation of the future of some number of nodes aligned beyond the 28 that Verizon has currently proposed. That's going to depend on a number of things, including, I know of none at the moment, although there may be a handful that are being, I don't know of any concrete plans that Verizon has at the moment. And that's going to depend on capacity demand, spectrum auctions, and equipment engagements. So it's always our first priority is to leverage not more assets. It's much cheaper, it's much better to market. So we don't want to build small cells unnecessarily, propose them unnecessarily. We'll only do that if we absolutely address capacity. So we don't have any concrete feature plans on the 28 that are with applications. And without a crystal ball really to judge the future capacity demand or what channels the FCC may make available down the road for auction, or what equipment enhancements will help us better deal with capacity demand. It's a question to answer. Thank you.
Thank you.
Hi. Sorry, this is Bonnie. I think Megan Riley was muted. She just wanted to make a quick comment.
Okay.
Thank you. Yes, Megan Riley, counsel for Verizon, and just to clarify, I am a Verizon employee. And thanks, Andrew. Everything you said was accurate. I just wanted to reiterate Verizon's concerns regarding the requirement that each and every small cell be field tested for RF emissions by a third party. This would be a very burdensome requirement that would involve a lot of significant additional costs and resources. That's just not necessary to ensure our compliance with the RF safety guidelines. As noted several times previously, our business depends on this. We are highly motivated to ensure our compliance by a significant margin. So I think this requirement would be so burdensome considered, in aggregate, if we had to do that type of field testing with a third party for every single small cell that we deployed, this would have a big impact on our deployment. And the law looks at requirements and fees relating to our deployment in that manner, in the aggregate, in determining whether something would materially inhibit our ability to provide service. And then I do cover a pretty broad geography in the Midwest and Northeast. I don't know of other municipalities imposing this type of individual field testing by a third party type of requirement. And I want to emphasize that we do have some additional resources on RF safety, and I think Andrew was displaying some documentation. We have expert reports and studies comparing the emissions from our small cells to everyday, exposure to baby monitors and Bluetooth. I think that's it. Thank you.
Thank you, Megan. Joseph, AT&T, again, we're
Yes,
generally trying to respond to recommendations 1 and 3 in the permit section.
Yes, very quickly, I agree with my colleagues. I want to also clarify, I am not an engineer, just for the record. The other thing I think with respect to plans for the future and the obligation of what our total deployment may be, if you look at the evolution of wireless, it has been, the networks have evolved because the technology and the customer demands have evolved. So I think in 2007, when the iPhone came out, I don't think anyone could have predicted the demands on our networks that we have seen since then. So again, like the city, we are not going to spend time and effort and expense on something that is not needed in order to provide service to our customers. So when we do come to the city, this city or others, with respect to infrastructure, it's because it's needed. And what is down the road is going to be contingent upon all those factors that Andrew talked about. Thank you.
Any other commissioner comments? Commissioner LeGree?
I'd like to ask Joe and Andrew both, what percentage of your installations are going to be out of the public right of way? Do you anticipate any being out of the right of way?
I'll let Andrew hit that first from an engineering standpoint.
Okay.
From what I've seen so far, I don't anticipate any out of the right of way. I've seen them in the past in other municipalities. It's not, I wouldn't say it's completely uncommon to do a small cell install on, let's say, a rooftop out of the right of way, but I don't know of any plans here that would take us out of the right of way.
And this is Bonnie, Commissioner, from Verizon as well. I don't believe we have any that are out of the right of way planned for Rehoboth at this time. None of them except for the ones on the boardwalk. So that kind of is a right of way or whatever, that may be not a right of way, but we have boardwalk nodes and everything else is in the right of way. There are cases where we have done replacement of flagpoles. For example, in Fenwick Island, we replaced the flagpole at the Chamber of Commerce there. And that is a small cell facility. 4G and 5G nodes are there. So that's the only kind of thing that we might do, you know, to that would be out of the right of way, but still would be a freestanding structure. And in that case, it's you know, on the Chamber of Commerce, on the property next, right there. So, thank you.
Thank you. I know you have no plans to co-locate or tack on your facilities, but what about your backhauling cables? Are you guys going to go ahead and use whatever poles you can tie on to? What are your plans? I remember Joe said you were going to use I think he said you'll use a third-party vendor. And yeah, what are your...
Yeah, this is Joe from AT&T, Commissioner. All our small cells must be connected, and they're connected by fiber to the public switch network, and we can use a variety of vendors, may all be who is there and who has facilities there. So recall, the only thing wireless about a wireless network is between the device that the consumer has and the wireless antennas that are part of the network. Everything else generally, at least in the context of Rehoboth, will run through fiber. So the other thing, we have no additional plans at this point for additional small cells. I would also note that it is all driven by the network and the engineers and where facilities are needed. So often they can be in the right of way. Sometimes it may be a parking lot that we replace a lamp, a street lamp, things like that. So it really all goes to the performance of the network, where the engineers determine that this facility is needed to better serve our customers. But all of our small cells are connected with fiber to carry that traffic to their destination and back.
Do you anticipate those will all be attached to existing poles that are owned by Delmarva Power or whoever?
All what? I'm sorry.
Can I assume that that those optics will be attached to existing poles that are currently in the right of way, and also you have a source of power? Is that a fair assumption?
Yeah, I think those, we have small cells are already operational and they're already connected. And I think the last one that we're going to do will be certainly connected to power, and it is actually going to be on a Delmarva pole.
Okay, no, that's my question.
And this is Bonnie Metz. That's the same for us too. We use our core landline employees to run our fiber in the state of Delaware, and they are on, to the extent it could be underground where things are underground run, or it could be connected to the existing poles.
Okay, thank you very much. I'm going to be a careful observer when you guys go through Henlope and Acres. It's going to be fun to see what happens over there. Thank you very much for your answer.
Listen, we have a very long agenda. There's other things that I would prefer not to cut. I would like to conduct this meeting. It's going to go very late. We've still got, what's your guesstimate, half hour plus for this topic. I'd like to suggest that we call this meeting or this topic to a close and continue it at one of our future meetings, so where we can devote more time. I found it very productive to have Michael Roberts here, as well as AT&T and Verizon reps and Heather Metz. But again, this could take another half hour to an hour to go through it. Are the commissioners amenable to calling it quits on this for the day?
I am.
Yeah,
I agree.
I think that's good.
Yeah, that's
Certainly.
good.
I have a lot more questions, but you're so correct. It's time to go on to another topic.
Well, we will continue this at a future date. It may be the November workshop meeting, but we'll try to get, we will get Michael back and the other representatives to participate so we can finish our task of the day, which was reviewing the recommendations of the Environment Committee. I want to thank members of the public and everybody that spoke on this, and we're going to call this a day. Thank you, Michael, and others for participating. And we're going to go to the next item of old business, which is to discuss a draft ordinance amending Chapter 270 of the zoning of the city code specific to changing the definition of gross floor area and adding a definition of underground parking area. What I'd like to do is have Glenn, again, just have a quick review of the genesis of this topic and the objectives of this topic, and then we'll talk about a timeline, remembering that this is a zoning issue and would have to eventually go in front of the public hearing.
Thank you, Mayor. So this, just a matter of genesis, this relates back to the Board of Adjustment application, if you recall. Both down with commercial applications, but decisions made in the Board of Adjustment hearing affected the way that our building licensing was required to review residential applications. So that was sort of information for the commissioners taking up this agenda item. It's gone on for several months, but the goal of this item has been since the outset to make sure that the residential applications and the review of the residential applications, the status quo is maintained. So I did spend some time redoing the underground parking ordinance, which is one I believe we're looking at first. So the underground parking ordinance, the things that you'll see incorporated in this version is first that this version is based upon some input from Commissioner Gossett and utilizes the term underground parking area. I did confirm that most of the parking industry uses that term rather than subsurface parking. So all of those references to subsurface has been now converted to underground parking. This version also incorporates the definition of underground parking area that was taken from an online legal dictionary. I think it seems to work okay for our purposes. This version does limit the exclusion of underground parking areas from gross floor area to those parking areas associated with commercial uses, not residential uses. And then finally, this version maintains the flood zone requirements that were suggested by Dr. Trejos. There is a little bit of a conversation going on right now between Dennis Jenny, our floodplain administrator for the city, and Dr. Trejos to make sure the terminology marries up. Mr. Jenny expressed a concern that if we don't get the wording right, the insurance rate people, our rate for the floodplain rate could go down or up, I guess, and we want to be sure that we get the wording right so as not to affect our flood insurance rates. So that's the overview. The first part we could talk about, I suppose, is the definition that's been included for underground parking area. That definition is any enclosed area containing one or more parking spaces used or intended to be used for the parking or movement of motor vehicles and contained entirely within a structure or part of a building, the whole of which structure or part lies entirely below the grade of the structure or building. So that's the definition that would be inserted for underground parking area. Down in section 2 of the ordinance, there would be an amendment to section 270-21B5. This is where the exclusion is for underground parking in commercial districts. So it says in all commercial districts, underground parking areas shall be excluded from the gross floor area. So there was discussion last time about whether this exclusion would also apply in residential districts. This is the area that clarifies that it's for the commercial and not for residential districts. And then finally, section 270-30 again is the language dealing with the floodplain. This was all generated from Dr. Trejos, who has recognized that there's been reports that the floodplain maps sometimes don't adequately accommodate underground parking type facilities, in that when you plan based upon the floodplain, the actual subsurface water level might be something different. So there's a discussion going on right now, like, as I said, between Dennis and Dr. Trejos, to try and figure out if there is language that we can include that would, in some ways, be a little bit more restrictive in my way of thinking than would be required under the current ordinance, to ensure that we take one more measure of core drilling analysis to determine whether the structure can actually be built as proposed or not. Then finally, in section 4 of the ordinance, you'll see there's a table, and the table is, this is in the parking area of the code, and the table goes through and specifically excludes underground parking from those areas in those commercial districts. This is generated from a discussion I had with Commissioner Gay. We thought maybe it'd be more appropriate to put it in this section 270-35 of the ordinance, and I think she's right, so it's migrated to that area. That's the review of the ordinance. Questions?
I have a,
yeah,
could I start? Glenn, thank you very much for the overview there. Just kind of maybe semantics, maybe not, but on line 129, where we speak of underground parking area, I just question the fact of the term area. Are we not trying to define underground parking or parking underground? To me, it is, it's kind of defining a parking lot versus a parking space. So if we stay with area as defined, do we also need to specifically define underground parking as below surface or something of this nature? Just the word area is concerned to me.
Like I said, the definition was largely taken from what I saw online. I'm not sure that the word area has anything magical about it. So is your concern that, maybe I'm not understanding completely, is your concern that there are other areas that can be considered underground parking areas that would be able to take advantage of the exclusion that aren't truly parking type areas?
That could be a possibility. It just seems if we were just to say underground parking would be a much clearer definition than a underground parking area. Again, there's discussion of an underground garage or a garage underground, something of that nature. It's just cleaner in the sense to me of just underground parking defined. And again, it may be semantics, but I just, trying to look down 3 to 5 years, how is that going to be interpreted and used? So
it's just a matter of striking the word area. I don't think that I have a problem with that. I think I want to take it under advisement and maybe look if it doesn't work somehow with other things, but it doesn't. I can't immediately say there's a problem with striking the word area. Yeah.
Okay. And then just again, for clarity in here, we also speak of line 132 and 133. We speak of a structure or part of a building, the whole of which structure or part lies entirely below the grade of a structure or building. We're intermixing the term structure and building there, and do we define structure and building as two different definitions that we need both in this definition, or is that, why do we use, I guess, the term structure and building?
The way I understood this, and it appeared several times in different definitions, so I wanted to kind of understand it myself. I think the concern is that you could build a underground parking structure that is not part of a building. There's no office space or anything above it, but it's in another location on the site, and it's underground parking. I think we still want to exclude that underground parking from gross floor area. So if it's just a structure that is underground gross floor area, that's different than a building that has underground parking as part of it.
And should that maybe be made clearer in the definition here as that interpretation, or that is your interpretation as we discuss it right at the moment. But again, 3 to 5 years from now, will that same discussion or memory be held that as it's interpreted?
We can certainly look at other language. I think the definition's being, I think it's technically accurate. Sometimes I'm concerned that if we try to explain it too much, then we get away from the technically accurate definition into something that, but let's, it's the first time I've introduced this definition, so maybe others have thoughts and maybe we can refine it.
And maybe I would go back to building and licensing to see how they are interpreting, and this may be fine, but just the practical application of this, is it working in the real world out there?
Right. I'm taking a look at it.
Can you two work together on that?
Yes.
Thank you. Thank you. Any other questions on this?
Yeah, I have one. Actually, I was planning to ask this before Patrick's comments, but to some extent he raises in the sense that I was just going to ask the question: have you spoken with building and licensing about not only the definition but where things are placed in this code, such that they would agree that the language is clear cut, that they don't see any ambiguities, that they can apply this tomorrow and be confident of the outcome? I guess that's one question. And the second question is,
let's answer that question.
Okay.
So that's the first question. We had representatives from building and licensing on the emails that you and I exchanged going through the applications, and I didn't get any feedback indicating that this wasn't a manageable ordinance, but maybe they just have not gotten to it yet. If anybody wants to comment.
So we'll have them double check and review.
Yeah. Just to know they're comfortable with it. Yeah.
Thank you.
And then the other question was just, do we define grade anywhere in our code?
John is here and he said no. I think that is probably right. Nothing doing code.
I would say, grade is very important because it should be on the zoning code. The zoning code doesn't address it. The building code does. The question is how we calculate grade. Whether we take the average of the surrounding area, or grade is going to be at ground level. Those are the things that may need to be spelled out.
I guess the way I would interpret it here, although we could add another definition, but this definition says the whole of which structure or part lies entirely below the grade of the structure or building. So I would say that the entire perimeter of the building, wherever the ground level is, this parking has to be completely below that ground level or that grade. And the structure, if it's a structure that's not connected to a building, it would have to be entirely underground.
Yeah, but to that effect, the only reason I say you have to take the average because be cognizant of that story. We have different grades, and that part of the building is 3/4 or more is a story. It's considered above grade. I don't know if it's that important to this ordinance, but on the building code, it does apply.
Under this, you can't to take advantage of the underground parking exclusion from gross floor area, you couldn't have any of it above ground at any location. I guess is my point.
Okay.
Any other commission comments?
Yeah, I have a couple more if I may. In lines, and just help me understand this if you can, lines 147 through 150, we talk about any one commercial floor in a mixed-use building in a commercial district may include one residential unit used in conjunction with a hotel, motel, or inn. Such unit shall not exceed 10% of the gross floor area of said floor with a maximum of 1,000 square feet. And I guess this is a residential unit on the commercial floor. Is this intended that a residential unit can only be placed on a commercial floor? And then how do we determine what is a residential floor and what is a commercial floor, and how do we apply the use of a residential unit on commercial? It's not clear to me, and maybe it's very easy to explain.
So this is existing code language. No amendments are proposed to that section. I think this is the instance where maybe you have an owner who lives in the hotel or a caretaker who lives there in the hotel. The purpose of that provision. Dollar management, additional.
I believe that's correct. I believe that's what that was put in for.
Okay, thank you. The next question I have is regarding the change there on line 17071. We say size of parking spaces, ingress and egress, maintenance, and then we add underground and subsurface parking in flood zone. I don't believe the phrase subsurface is defined anywhere. Should that be removed and just use the term underground?
So this is trying to deal with underground or subsurface parking of any type, not just the type that's completely underground. This is dealing with the floodplain issues. So here we want to be sure that whether it was entirely underground or just partially underground, it still has to apply with the new ordinance language you see at line 203. So Commissioner Gay raised the same question about whether it should be a separate definition or not. The way we try to deal with it within the ordinance is at, let me see if I can find it, like at line 209, for example, it says, and the proposed depth of the underground parking structure or subsurface parking structure where any portion is
That's right. Yeah.
be below that of the subsurface water table. So this is the only instance in the zoning code that I'm aware of where we deal with parking that is not completely underground, but at least a portion is underground. And I wasn't sure that warranted an entirely new definition for this one area where we address it.
So in other words, it's been defined as where any portion is below grade. It's just not in the definitions. It's here. Is that right?
Would it not be better to make it clear and pull it out as a definition, even if it's only in one line? I just trying to make it easier to use going forward.
If others think so, I don't think it warrants a separate definition. I just think it's a little bit overkill, and then we start talking for 3 more meetings about what the definition of subsurface parking is. And
okay, so then another question.
I'm happy to.
All right, so my other question though is, again, 270 or line 17071, we've just added on that phrase underground and subsurface parking in a flood zone. But the only area that we discuss that is in paragraph G, which is underground and subsurface parking in a flood zone. To me, in looking at this, by adding that at the top in the section 270-30, that also has an impact on paragraphs A through F. As this applies to underground parking or subsurface, then it should state that in each paragraph by the use of the word underground or subsurface. Because in A through F, we never mention the term underground or subsurface. We refer to parking spaces on premises, outdoors, in a garage, every parking space. So for consistency, I think if we add this, tack it on at the top in 270-30, that can impact A through F as opposed to only impacting G.
This section 270-30 is really kind of the catch-all section at the end of the parking section, which basically says, you know, in any other ancillary matters, this seems to be where they've developed within the code. And I thought this would be an appropriate place to put it. I don't think that the heading including underground and subsurface parking in the flood zone means that, you know, section B, for example, in all public and private parking lots, that doesn't automatically insert there in all public and private parking lots that are underground or subsurface. It just deals with public and private parking lots and garages. So I don't think the heading actually is going to influence. I will take a note to look at each of those individually to be But I don't think it actually influences those other sections. It's just, to me, it's just a header that says, if you're looking for any ancillary information that deals with underground or subsurface parking, this is the section where you'll find.
Yes, we will agree to disagree then. I just, we'll leave it at that then.
Thank you, Commissioner Gossett. Commissioner Byrne?
Thank you. Well, this is semantics also, and I want to go back to the definition of underground parking, line 132, and just help me understand the intent of the word entirely. That seems awkward to have in that statement, but perhaps I'm misunderstanding what the intent is. The whole of which structure or part lies entirely, as
Opposed to.
well, as opposed to just dropping the word entirely.
Okay.
So the idea is that the actual parking portion lies entirely below ground. There can be part of a structure or building above the parking area that doesn't lie below ground. But based upon the discussion we had last time, my understanding is that you wanted the parking to be entirely underground.
Okay, so you're saying that the word entirely clarifies the intent of the meaning. Okay, seems awkward to me, but thank you.
Any other commissioners?
Yeah, Mayor, I have one. It's may go to the same point. And in line 163, where Commissioner Gossett referenced the word area being struck there, but the definition is underground parking area. It's the area is in the defined term of underground parking, as it's stated on line 129. And I just want to be sure that including in the definition of underground parking area is the space that provides for the movement of vehicles. So a ramp that's going into the underground parking area, I would think is also excluded from FAR. Areas where vehicles are traveling to parking spots but are not specifically parking spaces would also be excluded from FAR.
That's right. For underground parking areas, any of those lanes, travel lanes, maneuvering lanes, they're area.
Okay, I think the in line 163 that the area, maybe it shouldn't be plural, but the underground parking area should be left in there as a defined term. So I think you were okay removing the word areas from that line, City Solicitor, but I think it needs to remain as part of the defined term.
I think it could go either way. The reason I say that is subsection C that you're looking at with line 153. 153 or subsection C is saying that when there is a requirement for a certain number of parking spaces, those parking spaces are to be measured exclusive of travel lanes and other things that are needed to get to them. So you can't use the travel lane to count your number of parking spaces. So C doesn't specifically deal with underground parking areas. It just deals with the parking spaces that are required. The only thing that's changed in subsection 27030 is section G, which is intended to deal with the FEMA flood map and underground parking. I mean, based on your comments and Commissioner Gossett, so I am going to go back and look at A through F just to ensure that there's not something weird that's in there that does get confused.
And just while you would go back and look at that, there was a discussion on lines, paragraph F, 9900 and 201. according to city specifications, and shall be graded properly, properly drained and maintained in good condition. I just question properly drained for a surface parking lot versus an underground parking area or parking. Wouldn't there be totally different requirements for drainage with an underground facility versus a surface facility? Whether it be addressed with pumps or something of this nature. I just don't know if there are different standards for surface parking when grading and properly drained with regards to, do they meet the same issues of a subsurface or below grade underground parking, of how that is maintained. We don't worry about that as long as you meet the properly drained criteria.
I'm sure there are different standards. This, again, subsection F is existing code language.
Agreed, but we're creating a new definition to go with that of underground parking. So does that need to have to also impact how we create a new definition for properly drained, or who determines properly drained?
So I think that I need to sit down with building licensing on A through F and just make sure that the insertion of G doesn't do anything or create problems in their eyes, because I mean, they're the ones that are going to be implementing this. I just saw this area as a catch-all for all parking provisions, not intending for using the word underground and subsurface to be applicable to all these other sections and create some confusion. So if it does, we need to look at it and figure it out.
Thank you.
City Solicitor, can I just ask one clarification? When we're talking about Section 2, which is the exclusion of the parking spots in the FAR or the gross floor area, is it intended that the travel lanes and ramps are included or excluded from GFA?
I'm sorry, so you're back at Section 2. So the intention is that the travel lanes, any area that is underground, that is used for, in the definition, the parking or movement of motor vehicles and contained entirely within a structure. So any area that's necessary to the parking. So travel lanes.
So that would all be excluded?
Yes.
I just wanted to clarify that. Thank you.
Any other commissioner questions? If not, let's talk the next steps. I want to talk timeline. Is there anything crucial that demands that this get done sooner than later? Do you have a deadline or?
Not in my mind. Matt, is there anything that's pending or going on the residential side that?
I don't believe so. Not on the residential side, certainly. The only thing that we would have is the relief that was given to 19 Baltimore and potentially some more of those hotels that are coming in. But as of right now, we have no applications for those. So.
Okay.
Well, I think what I'm getting at is, since this is a zoning issue, has to go to public hearing, can we put this on our November workshop meeting? Because I prefer conducting things like that at workshops. And then we can fine tune it, and at the November regular meeting, if we're ready, adopt a resolution to go to public hearing. Does that fit with everybody's timeline?
Yeah,
So at the November workshop, we'll expect the next version complete with a review by the city solicitor and also building and licensing at that time. Any other questions? Thank you very much. If not, we're going to go to the next item on the agenda. Old business is discuss the development of a draft ordinance amending Chapter 270 zoning of the city specific to changing the definition of gross floor area to clarify what areas are to be included and excluded from gross floor area. You know, I forgot Walter. Walter, forgive me. I'll get to you at the end of this topic, and you can mention both, if you don't mind. My intent for this meeting is more of an introductory discussion. Let's look at it, let's absorb it, ask some questions, and this would be continued to a future meeting.
Sounds good. So I've asked Kevin Williams to share his screen, which is going to be the presentation on gross floor area, but there's a little bit of a background. Remember, this was part of the previous ordinance we just discussed, and we decided to break it into two separate ordinances so we could deal with underground parking separately from more general discussion about gross floor area. So Matt and I met and we talked a little bit about, really since our direction was, prepare an ordinance that takes things back to the status quo so that in the residential review process, some outdoor spaces that weren't counted previously will not be counted going forward based upon the Board of Adjustments decision. So what that came down to is we started talking about, what's really creating the issue for residential reviews. Okay, we can hit the next slide. So what we thought is possibly on this gross floor area deal, as Matt and I were discussing different areas that existed, it all seemed to come down to railings and guards and guard railings and how they, based upon the Board of Adjustments decision, would now cause a reviewer on the residential side to include certain outdoor spaces that weren't previously included. So we looked to the building code because the zoning code does not, our zoning code does not have a definition of guardrail, or railing. We looked to the International Building Code that we adopted, the city's adopted, and fashioned a definition for guardrail, railing that resembles, was it guard, Matt, or was it railing?
It was guard.
It was guard. So it resembles the definition for guard that's provided in the International Building Code. So that definition, if we were to incorporate it into the zoning code, would be this: a building component or system of building components located near the open side of at-grade or elevated walking surfaces that minimizes the possibility of a fall from the walking surface. A guardrail/railing is not an exterior wall when associated with a residential use. So this last sentence deals only with the residential side. Therefore, it maintains the mechanism that has been implemented on the commercial side for counting certain spaces and whether guards, guardrails, and railings can be considered an exterior wall. Here we make clear that on the residential side, guardrail, and railing are not to be considered an exterior wall when associated with a residential use. So I thought I'd go through just a few examples, illustrations, and combine with some commentary on what is counted and what is not counted as gross floor area in each of these. We'll do that. So this is just a basic home structure here. There's no outdoor spaces to worry about being counted, so that's just what we're starting with. Matt?
So this would be a house with a deck, a patio, some sort of structure that does not contain roof. That is not a roof structure. It doesn't have a trellis. It doesn't have any kind of roof over top of it. That structure then would not be counted for floor area ratio, and it would be counted for coverage. So keep in mind, a lot of these things are still going to count as lot coverage, but not necessarily for floor area ratio.
And nothing changed in that sort of scenario based on the Board of Adjustment decision. You wouldn't have counted this space before the Board of Adjustment, and you won't count it if this definition is implemented.
Correct. Okay, again, here's the same scenario, but we present a railing at this time. Again, there is no roof structure, therefore it should not count as a floor area ratio and only for lot coverage.
However, based on the Board of Adjustment decisions, under the current scenario, this was the space that you would count.
Correct.
Yeah. But that was not counted previously.
Correct.
Okay.
Here is a roof structure over said patio, whatever we want to call that thing back. This will count for floor area ratio.
And it would count as practical.
Yeah.
It will continue to be counted. Okay.
Again, the placing of the railing does nothing here. it will be counted regardless, and it would be counted with the interpretation as well. Here, only the covered area is going to be counted. So the first floor is what we're representing here, would definitely be counted as gross floor area. The second floor would not be counted as it does not have a roof structure.
However, given the recent work
Correct. This scenario, both areas are going to be counted as floor area ratio, as both contain some sort of roof structure. And the interpretation that the board upheld would not have affected this one. Here again, adding the railing does nothing to it. It's going to be counted as floor area ratio. Screening is the same. It doesn't matter. It's a covered structure. It gets counted. This portion that we're showing here would be maybe a deck or something like that. The portion that is covered again would be counted as floor area ratio. The portion that is not counted would only be counted as lot coverage. And here again, it has been customary that the overhangs, exaggerated overhangs such as roof structures, the overhang of this type of house, it would be counted as gross floor area below it.
that area below.
Yes. This represents basically a shed or outbuilding. Customarily, it has, as long as it kind of meets the same rules as the basement rule, if you do not have a plate height above the 6'6", you can have that structure and it will not count against you as gross floor area. The garage scenario, this will be counted as gross floor area once it exceeds the 6'6" plate height, and there really is no scenario there that I can think of. If you extended those plate heights or not, it's still going to count as gross floor area. Here we represent, I see some squiggly lines, so it looks to me like that's a pool. If we go back to the original interpretation, this would not count as floor area ratio. With the board's interpretation, it would right now.
But if you insert the definition that we're contemplating, it would go back to then not being counted.
It absolutely would.
I think that's it. So that was just intended to give a few scenarios, give one approach that we're considering, which is, a new definition that might be a relatively simple fix to take things back to the status quo. But we were hoping to get some feedback before we prepare an ordinance to see if this is the direction the commissioners would want to consider, or whether there's other options we should be looking at.
Commissioners?
Let me think about this. I'll try, Matt, I think as I've mentioned to you before, it took a long time for me to learn about the way you count a structure based on whether or not it has a roof. And I guess I'm just wondering, where is that? Is that specifically spelled out in the code that it's the unroofed deck structures that we're really talking about here? And going back to the old interpretation where if there's a roof over a porch, the porch loses its 250 square foot exclusion, all that kind of stuff. Is that clear in the code?
So it is pulled directly from the front porch portion of it, and then the definition of open porches, open decks. It's kind of a correlation between the two there.
Okay.
For front porches, it does not give away that credit if you have it roofed. The only time you would lose that credit if you actually had living space above that front porch in your scenario there.
In which scenario? Because as it is now, okay, all right. But the way you used to interpret it before the Board of Adjustment change, or before that posting last September, a deck above a porch did not count.
The deck itself would not count, but the porch below it would definitely count, yes.
And so you would lose the exclusion?
you would essentially lose the exclusion for that portion. So if you had half of the front porch that was open, half of it wasn't, you would lose half of it. Yes, ma'am.
And that is the previous interpretation. That is the way it used to be.
Correct.
Okay.
Can I?
Well, Commissioner Taluzzi, yes.
Yes. Just, I wasn't totally clear, Commissioner Gay, with what you're saying, and I just want to point out, 250 square feet on a front porch is excluded, period. Whether there's something above it or not, that's what I understand. Is that what you understand?
No.
Is that what you're saying?
No, Matt, no. If there is a deck over a front porch, the portion that it covers is excluded from, is not excluded from gross floor.
Right, it would not be correct.
And that's the way it has been. It's just that it's hard for me to see that. I think these pictures, by the way, are great. And I think what would be good to have, both at a public hearing when we get to it for this ordinance, as well as just ongoing for anybody that stops in and has questions about building, it would be great to have an annotated version of these illustrations to show, exactly what is and what is not included. But that's the part that's what I'm saying, Pat. That took me a long time to learn that.
Well, Mayor, if I may, back when this was enacted a long time ago, the 250 square foot exclusion, wasn't it your understanding that 250 square feet of a front porch is excluded no matter what?
No, my recollection was that if it had a roof, then it counted. And of course, the 250 incentive was an incentive to people to put. It could be a roofed. I'm sorry. It could be a roofed porch, but it could not have a deck or living space above it. So even if it had a roof,
okay, then that's fine. That's not how I remembered it, but I will,
that's what they've been doing.
What you all remember and believe, so that's fine. I just thought it was 250 square feet were excluded no matter what, but that's fine.
So I do
want to compliment Building and Licensing Glenn on working together on this. I know they did pencil sketches and developed these. And I do believe that labeling would be very helpful, because I think we'll use this into the future to help explain this concept as well as others. So thank you very much. And we'll direct them to do that. Commissioner Byrne, did you have a question?
No, I'm fine now. It's clarified. Thank you.
Thank you. Anybody else?
Just to confirm that the code, and I do remember the 250 square foot, and the code, the way it reads, the first 250 square feet of an open front porch shall be excluded from gross floor area, provided that such porch is on the street side of the building at the first floor level, roofed, one floor, and no living space or deck above the porch.
Right, it does say that.
So,
correct, yeah.
It's in the code, okay.
All right, so let's, thank you very much. So let's talk our next step. Are we comfortable with Glenn drafting a ordinance?
Sure.
Yeah.
I'm unsure.
Yes.
Okay. We'll say that's definitive. We'll do that, and we'll have this diagrams annotated. If you have anything else to add to it, that's fine too, so that it reflects the ordinance and helps with it. And we'll put that on our November workshop meeting. Is that all right? Give you time? Very good. Thank you all very much. Next item is actually new business, and we're going to review the fiscal year 2021 city budget and capital improvement program, including financial impacts of the pandemic, specifically related to revenue loss, expenses to date, and recommendations to prioritize deferred capital projects. We'll turn it over to the city manager.
Thank you, Mayor. So we have a consolidated package for you, commissioners. You'll see you'll see that we have two packets of information that we provided for you. One is the fiscal year 2021 capital budget status update, and the other is the thicker packet of the revenue projections and forecasting. So I first want to just give you just a very brief, because obviously we have three commissioners, the mayor and two commissioners who weren't part of this discussion in March when the budget was approved. But as far as the capital budget, and this is again the page document that you see on your screen, what we have totaled in the first column, obviously the description in the first column gives you the budgeted amount, and the total spent is in the second column, total spent and obligated. So if you move down to the third page is what I want to concentrate on, and that those columns and rows going across. The entire fiscal year 21 capital budget, the original budget, at $5,474,573. Total spent and obligated on the previous two pages, $2,703,571, and then that difference there is $2,771,002. So that difference is the deferred capital items that we were able to put aside because they weren't. I'll say we waited to put aside until October now, when the parking season had concluded and we were able to review the numbers. So that was the original time frame that we had. We needed to get through the summer and look at the any revenue shortfall. Obviously, there was a revenue shortfall in parking. We're projecting a revenue shortfall in the new hotel tax that was instituted this year, and we also came up with a savings in operating expenses in this next line of $484,982. Much of that was cost reductions during the summertime relating to seasonal costs, seasonal workers, materials and supplies, and having every department head just review their budgets and be very tight on any expenses that they were spending. So we were able to manage that almost $500,000, realized almost $500,000 savings so far in the 6-month time period for this fiscal year. The next line, we're looking at total projected savings in capital and operating expenses, and then of course the revenue shortfall of approximately $1.9 million. That revenue shortfall is parking, the hotel tax that I mentioned, and again, being able to offset some of that with expense savings and projections. I'm going to have Mr. Dukes, the finance director, explain some of those projections and forecasting that he's done for the revenue. But for right now, we have a projected net savings of $1,352,019. So if you take that projected savings, and this is what we're proposing, staff and I are proposing, and recalculating that to put it 5 items below the prioritized capital projects below that you see in this section here. These are all items that were originally put into the capital improvement budget. They were all needed expenses, and obviously we deferred them at the time to see where we would be throughout the parking season throughout the summer. So the first one are the water meter replacements. We reduced the scope from $460,000 down to $360, just in order to do less of them. And you'll see these back, obviously, in the future year. Sewer line rehabilitation program, $360,000, again, a reduced scope of $100,000. And then we are including the Delaware Avenue restroom expansion project at $210,000. The Scarborough Extension rain garden improvements at $35,000. And the street sweeper, which is much needed, that we did not order at the beginning of the fiscal year, for $170,470. So that total gives us if you look at the line number 103 less line 112, that will give you a difference of $216,549 that we project will be the net savings. This is a very, very conservative number based on very, very conservative projections, and we believe there'll be more, but my recommendation is not to proceed any further until, again, we get closer to the end of the fiscal year, knowing what we can do with that. So this is really, I'll say a simplified snapshot. We spent hours going over this and trying to simplify it for you to give you the best snapshot of all of our predictions so far, 6 months into the fiscal year. So with that, any questions on this before I have Mr. Dukes go over the projections and his forecasting?
Sharon, the timeline on the Delaware Avenue restroom expansion, is that is so that it can be realized and ready to go for summer of 2021?
That's correct.
Very good, excellent. Commissioner Gossett?
Yeah, with regarding the reduction of scope in the water meter replacements and sewer line rehab program of a total of $200,000, is that portion of the project just going to be postponed to another year, or is that a reduction in cost of the actual total project?
No, it is not. It's not reducing what's needed. So it's reducing the scope right now, and then if that money can't be made up before the end of the fiscal year, you'll see it again projected into the 2022 budget.
So, for example, with water meter replacements, if we're going to replace 500 originally for the 360, we're cutting that back to say 300 or originally 460, cutting it back to 300, and only replacing a reduced number of the meters.
That's correct. Again, all of this that's in the original CIP, $5,474,573 are items that were listed and brought to the attention of the mayor and commissioners all through the budget identification process at the beginning of 2020, and then what was adopted in March of this year.
Thank you.
Very good. Any other commissioners? You literally need to raise your hand so I can see if you want to talk.
Yeah, Mayor.
Commissioner Byrne and then Commissioner LeGree.
Thank you. City Manager, thank you very much. Excellent snapshot, as you called it, and I really hand it to you and your team for managing expenses and savings over this last season. I do have a quick question on line 26, the boardwalk recycling containers. It appears that those were purchased.
That's correct.
And so it appears that we're ready to go with that program at the beginning of next season because we've already laid out the dollars for the new containers.
Commissioner Byrne, if you don't mind, I'm going to put that on the October regular meeting for an update and perhaps some photographs and stuff. So if you could defer till the October regular meeting, and we'll get a full report on that.
I'll sit on my hands until then. Thank you, Mayor.
Thank you very much. Thank you very much. Anybody else? Jay, you had something to unmute. Who unmutes him? You or him? Okay. Hold tight, Jay.
You're not on. You need to unmute yourself.
Am I okay now?
Yeah.
You're fine. Yes, sir.
This is crazy. I'll wait until Bert's done.
Okay. Mayor, I have a question for Sharon.
Okay, thank you. When there's a document on the screen, I can't see who's raising it.
Yeah.
You physically need to do it. So Susan, Commissioner Gay, go ahead.
Yeah, I did. Well, and this sort of goes along with what Patrick was asking about the water, and would we be doing the other parts of it later? That applies, I think, in my mind to everything on here. Do you envision that all of the deferred items for the entire capital budget will be discussed and probably be put on the next fiscal year, or some of them going away altogether? Or I mean, I think I heard you say that some of them may come back yet before the end of this fiscal year, depending on how the budgets work out, right?
Well, all of the capital items you'll see again. If not this year, definitely fiscal year 22.
Okay. That was
the projected, again, projected net savings of a little over $200,000, a very conservative number. Hopefully, we'll look at that again in February and March during the time of the next budget discussions, and hopefully be able to say what we can do this year, because all of these, again, everything that you see here in the first 2 pages of this document were discussed, and they're definitely needed to.
Okay, that's what I thought, but yeah, I just want to make sure. And the other thing is, I saw the item on here about the COVID sign, so it reminds me to ask. I think you had already said in a previous update you applied for the reimbursements for COVID-related expenses, right?
Yes.
Any sense of when we would be getting that, or even finding out how much we're going to get of that?
So we're working on that with the appropriate authorities, and you know, I really don't know at this point. It shouldn't be too much longer, but again, it's another state and federal agency. So as soon as we can, obviously we'll put it in. It's also, you know, I just want to throw out that, you know, there's grants received for certain of these projects that you know, will be put toward these expenses. So, you know, that's another part of this. We didn't want to overload you with that information, but we're certainly mindful of that.
Okay, great. Thanks.
Commissioner Chernowski?
Yes, thank you, Mayor. I just, I have a couple questions. On probably the prioritizing which capital improvement plans we include now and which ones are being deferred until later this year or next year. So maybe Kevin's maybe the one answer, but there's 3 things that that I think are important, probably more important than the Delaware Avenue restroom expansion, and that is the stormwater assessment and repairs, the sewer vacuum truck, which I thought was imperative not too long ago, and then the stormwater basin number 40. I thought were 3 critical items that I guess are not taking priority over the street sweeper and the Delaware Avenue restroom. So I don't, city manager or Kevin?
Again, I think all of these items are important. We were looking at a total number. to fit in, if you will, and one couldn't be done without the other. So I'll say in your stormwater calculation and what you see in front of you, it's either one or the other. Is that correct? So the total, we couldn't split that up necessarily. So we were looking at other items that were deemed necessary at this time. Yes. So Mr. Williams is shaking his head correct.
Thank you very much. No other commissioners have any comments? Let's go to Bert Dukes. And Walter Brittingham, if you're out there, I apologize again. We'll get to you at the end of the budget, and you can have comments on 3 topics.
Can everyone hear me? What you see on the first page is fairly straightforward. It's just really the summary of our work that is supported in pages that follow. And what we did, I guess I'll just go over sort of the methodology, how we approach this, but we looked at our revenue line items in the general fund, and we used projections either by prorating or by using a little bit of common sense. Most of the parking revenue is in, so essentially what we used was really the actual that we had to date. And the hotel tax is really the other big piece of the revenue stream, and that is that's hard to project. This is our first year. We budgeted very conservatively because other people told us that we were going to be over $1 million, and we said 800,000 would be our budget, and we're looking based on recent trends, and actually the month of August and July are sort of encouraging. So we're estimating that we'll get about 250,000 in hotel tax, and that's going to put us about 351,000 less than what we projected. Transfer tax, our budget again was conservative at 1.6 million. Feel pretty comfortable. I mean, with the 2 million figure, I think it could be higher. So those are probably 3 big pieces in the revenue that really caused that affected the change. So I think if you printed this out in landscape, you can see the comments we had on the side. So I won't really go through those, but I mean, we went through it line by line to come up with our revenue projection. On the expense side, we basically looked at our prior year activity, and we wanted to see what percentage of budget we had spent in the prior year versus the current year. It was a little more difficult to come up with the expenses. If you prorated it out, it looked like we were going to probably have about over 6% reduction in the original budget, which we don't really think is reasonable, simply because we think most of the savings occurred in the summer season, and they're not likely to continue at that rate. So we used a fairly conservative number on the expense, operating expense side. And I won't say too much about the capital because you've already just had extensive discussion on that. I'll stop there and just ask if there's any clarification required or any comments on how we approach this. I will say one thing, on the water, our water revenue, we assume that the water and sewer revenue are going to be pretty much on budget, and I think that's reasonable. We have probably as many people in Rehoboth more people in the off-season than we traditionally have. But we'll know more when we send out the October billing for water and sewer. That's our largest billing of the year. And if that is encouraging, that's where we may have more money for your choice capital projects. So that's all I have. Are there questions?
Again, with the document up there, you need to physically raise your hand so I can tell who to call on. Commissioner Jay Legree.
Thank you. Can you hear me okay?
Yes, you're fine. Thank you.
I would never have believed we could have done this well when I was thinking about it back in June and May. I can't believe it. And to only be down 1.9 is just phenomenal. I never thought it. But the sewer flow the water flow is a great surprise. I look at the occupancy rates over on the Chamber of Commerce website every other day, and I can't believe how well we're holding up. So, and knowing full well that the rental tax comes in along about tax time, I think I bet you will be able to get just darn near everything. And watch me say something stupid and jinx us, but I think it's just great. And Bert, you are true. This was very conservative. I congratulate you, and I don't congratulate much, but thanks for everything. Keep up the good work. Thanks, Mayor. Very good. Thank you. Commissioner Gossett?
Yes, I'd also like to compliment City Manager Lynn and the entire staff. This is really a very pleasant surprise and well managed in that regard. And we certainly feel that confidence going through the rest of the year with your projections coming through. Just one question with regards to the water revenue. Is that increase, would you feel that our rate increase of the waters, that's really reflected of why that revenue is so higher? And then a second part of that is, when are the October billings going out within the next few days or week or 10 days? You know?
Well, I think you're right in that the rate increases have a lot to do with it. I'm not expecting a tremendous increase in volume of water usage in the third quarter, but we could be surprised. But yeah, I think most of it you can attribute to the rate increases. One of the other things that really sort of surprised us was the rental tax. I thought if you'd asked me in March or April what the rental tax is going to be, I would say we're probably going to be half of what we budgeted. But it seems that people wanted to escape the metropolitan areas or come down and stay, because the rental revenues, according to the real estate agents, have been pretty solid. So I think we're going to meet our budget in the rental tax.
And yes, Commissioner Gossett, the bills will be going out this week.
Thank you. And one other question with regards to, we're speaking about tax, the hotel accommodation taxes. What is the process that the city uses to actualize the amount of tax collected from the hotels? I know they pay an 8% and ours is 3%. What mechanism do we use to realize that 3%?
Well, it's essentially a piggyback tax, because they file their 8% tax with the state, and the form that we use is essentially the same that hotel owner would use for state filing, except our rate's 3%. So there's not a verification process in place right now, but city manager is working with the state, and the county has requested access to the state's database where they can go ahead and check these reported amounts. And I mean, basically, I can't imagine a hotel owner reporting a different number on a state form than we would report on the local tax form. But I think, we are probably going to have to develop access to a tool to monitor that going forward.
So if I may also just add that the business is required to send in what they've also sent to the state. And as Bert just said, we're attempting to verify that with the state, just as the county is doing. So we haven't yet been successful with that. I've been in communication with the state offices, but just haven't gotten to that success yet with the state, but we're working on it.
Thank you. That sounds great.
All right, any further commissioner comments? If not, we're going to go to public. Walter Brittingham, please. Walter? I hope you're still there. If you would talk about any comments on gross floor area underground, gross floor area clarifying definitions, and the budget, please. Just 30 seconds.
Thank you.
Mayor, I've apparently lost all sound. Is it for everyone or just me?
Can you hear me? Can you hear me?
Yes.
I can hear Pat.
Yeah, I can.
Dick?
Okay, I didn't hear Walter at all.
Well, he's
No,
muted now.
Walter never spoke.
Oh, okay.
So where are we now?
All right. Something was happening, I'm assuming. I didn't hear anything.
No, I think the man was waiting for Walter's delay to catch up.
Okay.
How long are we?
All right. Can we move on to the fog topic?
Please.
And again, my expectation is to not complete it necessarily, but to get a good introduction to it all. Sharon?
Thank you. Thank you, Mayor. As a matter of introduction for the mayor and commissioners who may, I think some of you have seen some of this and maybe others have not seen any of it, but we'll try to fill everybody in on just a brief discussion of the past and how we got to this, and I'll turn it over to
I'm kind of locked up right now.
to the Director of Public Works, but he's locked up right now, so. Not literally.
Max to the rescue again. Thank you, Max. So Sharon asked me just to bring a little update on where we got, or how we got to where we are with our stormwater management on the avenue and kind of the commercial area. So if you recall, back when we were trying to get a permit for the ocean outfall for the wastewater treatment plant, one of the requirements that DENREC levied on us was to conduct an analysis of our stormwater outfalls and the quality of our water that exits into the ocean. We expanded that, I guess, to include all of our outfalls, both ocean and lake and canal. So we had PhD under contract to do that modeling and do that initial analysis. So that was under phase 1. We did some preliminary testing, but basically a modeling of where our stormwater how it got to the ocean and then where it kind of flowed once it got to the ocean. So they could look at that in relation to what we were projecting our wastewater outfall would do. So the second phase involved a much more detailed sampling of all the outfalls, and some of the things that we determined as a result of that was that we had a much higher level of the bacteria readings in the commercial area than we did in our residential areas, and it caused us some concern, so we wanted to continue looking at that. And it also highlighted some deficiencies we had in the maintenance and operation of some of our stormwater structures. You'll recall our vault at Denver Rehoboth Avenue and maybe also the Wilmington Avenue sand filter. So then in the follow-on phase, then we did some more detailed sampling just in the commercial area as we tried to identify potential sources of the bacteria or food sources for that bacteria to continue to grow. In that also, we did some community outreach, did some public education. We actually held a session here at City Hall and had invited all the restaurateurs to send a representative, of which one person showed up. But we also did some walk-arounds. The building licensing folks, our consultants, Evan and I went around to various restaurants, kind of going and just talk to them about our program, what we were trying to accomplish, remind them of some of the grease trap requirements, where they're storing trash, all those kinds of things that we felt might be contributing factors to the high levels of bacteria in our commercial district storm sewer. So our phase 4 is we did some of that this past year. We did some more testing at the sand filters and at the vault. But the other thing we had, which we're going to continue on today in the discussion, was the development of draft ordinances that would help us do some enforcement in the commercial area, specifically with regarding to the fat, oils, and grease, as well as solid waste and how that's stored. So that kind of gets us back up to where we are today, and I guess I'll turn it over to Matt and Dennis as they talk through the two various ordinances under discussion. Certainly. So we looked at the grease trap interceptors, something specifically I looked at more. What we recognized is there wasn't a very good record-keeping system through the restaurants. So as we did our rounds last year and the year before, we reiterated the fact that we were going to be coming around as part of this ordinance and looking at the record keeping a lot more, inspecting the areas of concern with the grease traps to make sure that the areas underneath are free of grease, free of any debris, anything like that. And an ultimate goal, obviously, to clean up the runoff systems. What we've come up with, or what Glenn has come up with, is a pretty good ordinance that begins to touch on the grease traps and the maintenance and installation, etc., of these grease traps. And I don't know if Dennis wants to speak to the refuse containers, but there's also some stuff in here about proper disposal. Obviously, keeping your dumpster areas clean, and the maintenance there that goes along with that as well.
You have anything to add, Dennis?
No, the only thing I've got to add is, as Matt had said, this is much more thorough and detailed as far as keeping records. If you recall the current code basically just states that they will keep a record. So this is going to help us when we go out and inspect these restaurants. The other thing that we changed is that under penalties. As we've been doing in the past with some other ordinances, we've been changing to civil citations, which makes it easier for us to enforce, which has been working well with the other ordinances. Any questions?
Any commissioner comment for me? I do have a fair number of comments, and I think to be easy on everybody, I would like to email them to you all, and so that you can review them. So that we don't take up any time today. Again, is there any timeline that we need to be following with this? Do we have a deadline to achieve?
Well, we wanted to get this done sooner than later, so we can actually start with the requirements, re-notify those businesses again that and restaurants that need to comply with this. So by the end of the year, possibly, I think that's a good time to put that through.
Okay, we'll shoot for that. So I think we can put this on our November workshop agenda again, and then maybe we'll be ready to move to a vote in November or December, get that taken care of. Good job on all that.
Just one. Mayor, could I ask a question?
Commissioner Gossett and then Commissioner Szymanski.
Thank you. I think these are very comprehensive articles that need to be reviewed and hopefully put into place. Just a question though, with regards to the grease interceptors. Are all current restaurants required to have them? Even the older restaurants that were retrofitted or something of that nature? Is that addressed any specific? I know we have a 1999 date, but any of our restaurants precede that date. Do all restaurants currently have a grease interceptor?
That is correct. They all do.
Thank you.
Dennis or Matt, have you had any discussions with the businesses and gotten any feedback from them on this ordinance and the obligations it would have on them?
So we were very upfront about coming up with, when we were making our initial rounds and doing the initial investigation of this, we were very upfront saying this is going to be leading to a wider ordinance, and most of them, we're all in agreement that they wanted to keep the business flowing and keep the people coming into the seat, so they were more than acceptable of these ordinances.
Okay. And one last question for the city solicitor. The penalties, will they be in the name of the business, or do civil penalties have to be in a individual's name?
That's a great question. The civil ordinance, I believe, allows for business names to be named. I'll check that as the meeting continues and get back to you.
Okay, thank you.
Any other comments from the commissioners? Can you see if you can access Walter while I keep talking? See if he can get in online. The next business that we've got on the agenda is new business, review of commissions, etc. What I'd like to do, because of the time constraints today, unless you all want to go to 1:30, 1:45, I will consider deferring this to the next meeting. As I said earlier, all the committees can continue to function as they have been. Now some of the committees have new chairs. The one exception is the parking committee, and for the parking committee, it doesn't have chairs yet, and I think that's probably fine deferring that as much as another month or so. I normally would like this to be on the November workshop meeting, But if we have a light October regular meeting, if that's all right, we could put it on there to review. I'm not trying to rush anything. My intent was to discuss committees and mission statements, et cetera, today. Continue discussion at the November workshop meeting and then vote on any changes at the November regular meeting. We can still do that with a new schedule by talking about this at the October regular meeting as the first meeting discussion, the second meeting discussion in November workshop, and then a vote. What's your pleasure?
Mayor, I agree that we should defer this to the regular meeting and discuss it then again at the workshop and vote in November.
Great.
All right.
Sounds good.
Yeah.
I just don't want us to lose time because even though I think we could have the two meetings, a regular meeting and the November workshop, at some point we have to approve new members of committees. And I don't know if doing it in that time frame will allow us to be ready to do that at the November regular meeting or not. But I'd be happy to continue it at the regular meeting this month.
Well, and if we're not comfortable with the timeline as we go on, we can conduct a special meeting or defer it till later. Commissioner Gossett?
Just a comment, could we then, as Commissioner Gay said about appointing people to specific committees that are vacancies, could we perhaps take those committees first that need attention or members to be appointed and work backwards or down from there, as opposed to others that are set like audit committee or what have you? Some of these may not really need much attention.
Yeah, I think we can do them all together, but we can give consideration to that if need be.
Yeah, I mean, what I basically told several people is the entire committee, they're annual appointments. So everybody, like for instance, on my tree committee, everybody knows they're kind of up and I'm, and I may be looking at new people in or whatever, but it's all, we'd be voting on the entire committees when we vote, right?
Everybody can stay a member until such time as their new appointments arrive. So they should expect to continue to participate.
Okay.
Thank you very much. I would like to finish the rest of the agenda. The next item of new business is discuss program and timeline for review of recommended rewrite of the tree code by the Law Oversight Committee. If you recall, the Law Oversight Committee really didn't do an amendment job. They reviewed it and rewrote the tree ordinance, and that's been given to us. I want to thank the Law Oversight Committee, and what my recommendation would be is I wasn't intending any discussion today, but rather to charge Liz, our professional arborist, with a review of what's been proposed, to compare it to what the original objectives are to see if they're still being met, and giving her the charge to give us the best recommendations, but at the same time asking her to share the new tree rewrite with other stakeholders, such as some of the tree companies and the landscaping companies that have to apply this, and giving her until, say, the December workshop, and be able to sit down with us and give us her best recommendations. I'd like some feedback on that, please.
I think it's a great idea for her to, she's the one who's been really implementing this tree ordinance. So for her to look at both and figuring out whether they're both meeting the needs, or the new one is meeting the needs, I think that is a great way to start.
Thank you.
I would just say that I've witnessed many of those meetings, and Liz was very involved with the Law Oversight Committee. So it almost seems like it might be a little redundant for her to go back and review it again and provide us recommendations when she was very much involved in the process.
Well, one of the things that I've talked to her about doing is modeling, taking the new ordinance and applying it to permit applications that she gets in, and applying the old code and the new code so that we can see what the differences are. Hoyt actually already went to a lot of trouble and did a great deal of work doing that exact exercise, but he used the comparison of the cases that went before Parks and Shade Tree and how how they would have been, and so maybe some of them wouldn't have gone, but at any rate, he used those cases, whereas most permit applications don't go to Parks and Shade Tree. So, and when I talked with Liz about that, she said she wanted to do that comparison as well. So I think that would be very meaningful. And as far as I know, it's something she's planning to do.
That really makes good sense.
All right, so we'll incorporate a lot of those ideas in, and I'll approach Hoyt as chair of the Law Oversight Committee to see how he wants to participate as well, because he would certainly be a valuable partner there in sharing how they develop the new code rewrite.
And I'll also say he reached out to a lot of people to get their feedback, and I've gotten some of it. I don't know if everybody sent us all the feedback, and I purposely am sort of putting them aside because I don't want to read them piecemeal and then forget. I'd rather try to see what the common themes are. But I know we've gotten everybody that I think had attended any of their meetings got the invitation to comment. All of the tree committee members got the invitation. Parks and Shade Tree already weighed in with their comments. So I think once we get ready to talk about it, one of the things we should make sure we do is read first all of the things that have come in and talk about that.
All right, thank you very much. So we're going to set this in motion. Target date, December workshop meeting, unless we think we need a special meeting. But let's target that and give that a start. Any other comments on this? If not, we'll move to the next, which is commissioner announcements and comments. Just FYI for future agenda topics, we're going to continue with subterranean parking and the GFI issues. I do have a permit of compliance for us to hear at the October regular meeting. I've asked for an update on the canal project at the October regular meeting, including financials and timeline for completion. Recycling update, we'll look at the committees. We'll continue with wireless at the November workshop meeting. So we've still got a full plate going forward. So I thank you for all your time and commitment today. Our next, any other commissioner announcements or comments? Commissioner LaGree.
I just want to say that on Thursday at 2:30 p.m., the Rehoboth Beach Museum is going to have an event, and David McDonald is going to talk about what it was like before the Bay Bridge. And it's a Zoom meeting, so sign up, and somebody will send you a Zoom invitation, and you'll be able to talk about what it was like before the Bay Bridge. As a matter of fact, my wife used to come over on the ferry, so she'll be interested. But that's RehobothBeachMuseum.org. Sign up and enjoy the meeting on Thursday.
Thank you. Thank you, Jay. Any other commissioner comments? If not, review future meeting dates. We have a special meeting tomorrow, October 6th at 3 o'clock for the pandemic focus. We have a special meeting October 7th at 10 a.m., in which to conduct executive sessions on legal matters. And October 16th is the regular meeting. November 9th is the next workshop meeting. Citizen comment is next. Walter, we'll give you one more shot. I'll move to the next, which is commissioner announcements and comments. Just FYI for future agenda topics. We're going to continue with subterranean parking and the GFI issues. I do have a permit of compliance for us to hear at the October regular meeting. I've asked for an update on the canal project at the October regular meeting, including financial timeline for completion. Recycling update, we'll look at the cities. We'll continue with wireless at the November workshop meeting.
We need to give Walter a Zoom invitation.
Yeah. That's 30 seconds is a long time.
Hello,
Yes, we hear you.
and
Hello? Okay, I don't think Walter's on there, maybe he's dropped off. With that, I'd like to thank everybody that makes presentations. For the quality of your presentations are getting much better, and I think they're much more helpful than just oral presentations. Also, Sharon, if you could ask Andrew from Verizon for his slide that he showed today, send that to Ann so we have it for our records. And otherwise, we'll call this meeting adjourned at 12:58 p.m. Thank you very much.
Thank you.
Thank you.